I've read the case that we hold, where it's 1960 case.
Which is,
Major Jonathan V. Smith.
I got a better one.
Which case is that?
Check the
I've read the motions, so, have you read the motion? It's definitely not the 1905.
It's 1960.
Yeah. Yeah. This is talking about third degree of conflict.
Leo Martinez, did he just leave?
He's in the hallway right there.
All the cases are talking about affinity, something to ownership, which is really not.
Government code sections.
I never looked at the government code does. I look at the motion. Yes. Yeah.
And I he has prepared a wonderful motion, and I'm very proud of the work that he has done. He's advocating very powerfully. Why don't you actually open on
Get your copy.
You can highlight it for me?
Yeah.
Brenda, what did you want?
If you're not voting.
Oh, just give me one moment.
I guess I'll just go back. Yeah. Just hotter here this week. Always. It's not like you're bringing up here. I did. Yeah. Brenda said it was 80 yesterday. Now it's 76. Yeah. It's always hard. I was gonna do
One I read said no, it's.
All right, Mr. Calkers?
Yes, I wanted to.
Yes.
I wanted to go to court. I filed a motion, and I thought it had already been filed during the lunch hour, but I prepared some case, brought some case law that's highlighted and some charts and some different stuff with regard to the case. I didn't file all of that. I just filed the motion itself, but I thought I'd give it to the court because it's kind of lengthy. And they didn't get to us, so we should have it.
I'm sure we'll get to you.
All right, I appreciate you.
All right, is that Mr. Keonis?
Mr. King, right?
Mr. King.
Okay, we're just waiting for Keonis.
You know, they're having a party break.
Ah, okay. All right, Brenda, you ready?
Yes, ma'am.
All right, could the parties on Keonis approach, please?
Sorry.
Court is calling 2021 CR 9806, State of Texas versus David Keonis. They have parties announced for the record for the state,
Marcus Sanders.
for the defense.
Leo Gonzalez.
And are you Mr. Keonis? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keonis, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding on count two, waiving count one.
Any objection?
No objection, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review this document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor, I did.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Keonis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
I did.
According to the plea bargain agreement, state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison. There's an affirmative finding of deadly weapon. State opposes your application for deferred adjudication, and there's to be no contact with Carlos Ochoa or David Gonzalez. Did you understand that to be the plea bargain agreement?
I do understand.
Defense, is that the plea bargain agreement?
That is the plea bargain agreement.
State, is that the plea bargain agreement?
Yes, sir.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
I did. Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in the indictment and count 2. How do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offer states exhibit 1 and its attachments. No objection, Your Honor.
Mr. Keonis, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes,
That's right.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll be back on September 26th at 9 a.m. Will there be any witnesses, state,
No, Judge.
defense?
There may be one, Your Honor.
All right, so that'll be at 9 a.m. Is a TAP evaluation or a MIC evaluation needed?
Yes, Your Honor.
All
Definitely
right.
a mix.
All right, so we're going to do a TAP evaluation and a MIC evaluation. And probation, make sure it's MIC MyOff evaluation. All right, if there's nothing else, we'll see you back on September 26th. At that time, I'll base my decision on your application based upon any evidence that's presented to me and the PSI report. All right, thank you. You're welcome. All right, who's here on Theo King? What is happening with Mr. King?
Reviewing the offer.
Okay, all right, thank you.
He's taking the offer.
All right, thank you. Just do the paperwork and we'll take that up. And I'm sorry, on Alexis Morganfield, again, state, which case are we proceeding on?
I'll be speaking for the state on that one. I don't see him right now.
Okay, all right, thank you. And then Leo Martinez, what is happening with Manuel Rodriguez?
We're ready, Your Honor. You understand he's our attorney. However, he's not here. Doing a-
All right, Mr. Manuel Rodriguez. Your attorney needs to be ready for trial because this is a trial setting today.
Judge Mary Peterzak here for Lee Cutter
Yes,
on that case.
so y'all ready?
I don't believe so, Judge. I think that she just got hired on that case and she hasn't gotten the discovery yet.
All right, this is a 5 setting case, so it's going.
I think she is in the family law conference. I'll pass that on to her office and let her know. I know that they had talked to Norma earlier. She said that we just need to somebody need to come and show up and approach.
Yes.
So it
Yeah.
sounds like,
It needs to be somebody who's to show up to be ready for trial.
okay, Judge, are we first on the list?
You're up high.
Hot on the list? Okay.
Yes.
I will pass on those words to her office and let them figure it out.
All right, thank you, because I haven't signed the motion to substitute counsel. Sometimes I know that people are hired on cases and they don't know that it's, yeah, we're going to jury trial.
So is Lee I guess, the attorney then, or no?
She's not the attorney of record yet.
Oh, she's not the attorney of record yet.
No,
Okay.
he still is.
You're still the attorney, right? Okay.
So she needs to know that if she wants to sign on to this case, she needs to be ready for trial.
I will pass that on to her.
All right, thank you. All right, the court is going to call 2021 CR 4507, State of Texas versus Theo King.
Present, ready, Your Honor. Ready to approach?
Yes, now parties announced for the record for the state,
Marcus Sanders.
for the defense.
Joanne Dooley.
And are you Theo King?
Yes.
All right, Mr. King, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. And first amended motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? Are you the same Theo Bernard King who was placed on deferred adjudication in 2021 CR 4507 for the offense of theft of a firearm on June 28, 2021 for a period of 4 years? Is that you? State?
On or about the 30th day of June 2021 in Bexar County, Texas, the defendant Theo Bernard King committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
On or about the 30th day of June 2021 in Bexar County, Texas, the defendant Theo Bernard King committed the offense of interfere with emergency telephone call in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive the others.
Any objections to the state's waiver?
No, Your Honor.
Mr. King, did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violations 1 and 1? Court will find violations 1 and 1 true. Is there an agreement?
There is one.
And what is the agreement?
We are asking the court to grant the motion, adjudicate and revoke and sentence him to 1 year in the state jail. In exchange for his plea of true, we've agreed to TIC cause number NIGhtMag 669397.
And I believe it's also misdemeanors.
Yes, and the arrangement is for him to plead to time served on the 2 misdemeanors.
And what are those cases?
Sorry, good afternoon. I believe he's got a assault violent matter of 665-2021. And a fine for 12-665-219. And I believe Joanne Eagle was here and I talked to her. She's just a misdemeanor.
All right, so 655-219.
665-220 and 219.
Correct.
And those were, she said she'll handle that with the county court.
And I'm just sorry, 665-2.
19 and 220. 220 and 2219.
Okay.
It's very confusing.
Yes. 655-220. Oh, wow.
665-220 and 219.
Okay, got it. That's okay. All right. Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right. Is that a yes or no?
Yes.
All right. The court will follow your agreement. The court is finding you guilty, will not grant you community supervision, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration NIGhtMag number 669397. The state agrees to give you time served and cause number 665220 and 665219. Is there any restitution that's due in this case? All right. Was part of the plea bargain agreement was restitution, if any, to Gabriel Perez.
Nothing was.
Okay. So I'm assuming probation, nothing has been submitted.
He left right after probation, so he never had to introduce him.
Okay. Mr. Hoyos?
Thank you.
All right, then that will be the court's final ruling. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Do better. Know better, do better. I think that Bernard, we can go off the record. I think Bernard King, that name comes from somewhere else, so you need to respect that name. Thank you. Yes. All right, where is Michael Villarreal? All right, who is here on roll?
Did I?
Garay? How do you pronounce your last name?
You say the words Spanish that I.
Garay? Okay, I'll remember to say Garay. What's happening on Mr. Garay?
Did we're not ready today, we're asking for another setting on it. The last setting in July was to hire an attorney on the current legal days before that. There's some discovery that I need to address with him specifically.
Who was the previous attorney? Because this is set for jury trial.
Your chair is the previous attorney, and I think he was left with the last. Well, we substituted in because the court had set it to hire an attorney on the last setting,
Can I see the file on Garay or Garay?
and we substituted in, I think, 27th.
Oh, I do. I'm so sorry. I'm asking you for something and I already have it. Oh, okay. Norma doesn't have this listed as a jury trial setting. She has you reset for August 23rd. I don't know why it's here.
Never gotten the setting.
That's what's written on here from July 7th. It says reset August 23rd.
That was the date the court had given us, but then you got notice for today.
All right, Ms. Ferguson. Raul Garay, is that August 23rd? Mr. Garay, come forward.
I'm thinking had a brother.
Yes. Yeah, he did. That's why I was like, let me look at the calendar because the file shows that you're actually set for August 23rd. So, and I have the acknowledgement of discovery is actually from July 7th, and that was done by Judge Angelini. So your reset date is August 23rd. State, have you given him an offer?
Yes.
All right. So August 23rd is going to be your plea deadline date and also your jury trial date.
Okay.
All right. We'll see you back on August 23rd.
Thank you.
Judge Kemper.
Yes. That one's done. All right, I'm sorry. Which case are you proceeding with on Morganfield?
1804. 2021 ADCR 1804.
All right. And Deputy Laura, when you all get a chance, can you check to see if the jury's here? Jaime Rivera. Court is calling 2000, I'm sorry, Miss Ethel, you need to be on this side. Court is calling 2022 CR 1013, State of Texas versus Jaime Rivera. Can I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Joanne Akel for Mr. Rivera.
And are you Jaime Rivera? Yeah. All right, so here's the rule, Mr. Rivera. If you have an interpreter, you use the interpreter. My Spanish is not the best. Well, who am I kidding, Brenda? It's not the greatest either. But what I do know is you don't say yes in Spanish if you're speaking Spanish. I do know that should be C. So if you're going to use the interpreter, use the interpreter. Right. Yes. Do you need an interpreter? Yes. All right, let's start speaking in Spanish then. All right, if I can have the interpreter, if you could raise your right hand for me, please. Do you solemnly swear you will faithfully translate from English into Spanish and from Spanish into English, so help you God?
I do, Your Honor.
All right, and if you could state your name for the record.
Norma Muir.
All right. And are you Jaime Rivera?
Yeah.
All of the documents I'm going to review with you are in English. Were those documents reviewed with you in Spanish? Yes. Counsel, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Rivera, did you review a document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Yes.
Did you review a document entitled True Bill of Indictment with your attorney? And did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count one and proceeding on count two.
Any objection?
No objection.
Mr. Rivera, did you review a document with your attorney entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions? Did you sign it in all the appropriate places and did you understand it?
Yes,
Did you understand and count two, you're charged with the offense of possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
yes,
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes,
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes,
Did you understand if the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
yes.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Rivera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea bargain agreement?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
no,
Ms. Eckel, according to the docketing sheet, it shows that an immigration attorney was appointed to represent Mr. Rivera for his immigration issues as it relates to this criminal case. Is that correct?
that is correct, Judge.
And do you know whether or not your client had a chance to speak with that attorney?
I know that he did have a chance to speak with that attorney.
And do you know whether or not your client has been advised of the consequences of pleading no contest or guilty in the application of federal immigration law?
It's my understanding that he has been so advised, Judge.
And do you believe that, or do you know if that advice included possible consequences such as deportation, exclusion from admission of the United States, or the denial of naturalization?
It's my understanding it did, Judge.
And do you believe your client understands the consequences of entering this plea and its effect on his immigration status?
I believe he does, Judge.
Mr. Rivera, did you have ample time to speak with your immigration attorney who was appointed in this case, Mr. Garcia? Yes. Did you receive advice on the consequences of entering a plea of no contest or guilty in the application of federal immigration law? Yes. Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization? Yes. And do you understand the immigration consequences in entering a plea here today? Yes. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the page entitled plea bargain with your attorney? Did you understand? Yeah. According to the plea bargain agreement, the state is proceeding on count 2. There's to be a $1,500 fine. State recommends deferred adjudication. State will take in consideration 2022 CR 5310. And there's restitution of $114 to San Antonio Police Department for laboratory testing. Did you understand that to be the plea bargain agreement, Mr. Rivera? Yes. Defense, is that the plea bargain agreement? State, is that the plea bargain agreement?
It is, Judge.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? And did you sign it in both places? Yes. Did you understand by signing that you're waiving your right to appeal, Ms. Echo? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Yes. Counsel, have there been any such motions?
No, there haven't, Judge.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Yes. Then to the offense that's charged in count 2, how do you plead? Guilty, not guilty, or no contest? No contest. State, any evidence to support the defendant's plea?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objection, Judge.
Mr. Rivera, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places? Yes. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Yes. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Yes. Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
I'd like to, yes, Judge.
Anything you wish to say on behalf of your client?
We just request the court to follow the plea bargain agreement.
Mr. Rivera, do you have any children?
Yeah.
How many?
Both.
What are their ages? 5 and 7. What do you do for a living? I work in construction. And where are your children? Do your children live with you? No. Do you support them financially? Yeah. All right, this is what the court is going to do. $1,500 fine, probated, 4 years deferred adjudication. Take in consideration 2022 CR 5310, $114 restitution to SAPD for laboratory testing, 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be parenting classes with Compadre, Once you complete those parenting classes, the remainder of your community service hours will be waived. Proof of employment within 30 days. No employment as a home health care provider or with minors. Random UAs. Field visits 2 times per month for 6 months. If there are no issues, then that can be discontinued. There's to be regular reporting by Zoom or in person. And probation will let you know if it's to be in person or by Zoom. Probation, is there anything else you need?
No, Your Honor.
Mr. Rivera, is there anything else you need from the court in order to be successful? No. Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it? Yes. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes. All right, good luck to you. Thank you. Probation will go over his conditions with him, and she'll need the interpreter. All right, do we have all the jurors?
Yes, Doctor.
Okay. All right, who's here on Thomas Henson?
I am, Your Honor.
Good afternoon.
My client is set on Thursday and he's being challenged rehab. And so we're asking if he can appear via Zoom or just have his case reset.
Oh, he can appear via Zoom,
Perfect. Okay.
and Ms. Ferguson will give you the Zoom number. All right, just contact her.
Okay. And then I had another issue. I'm not sure if you
Okay.
got the file there. yet.
And let me, Norma. I'm going
Daniel
to, there's going to need to be a Zoom link for Henson. And I'm typing in the information for you. For Thursday.
Thank you.
All right, and I'll note in the document file that he's going to be by Zoom.
And I have Mr. Daniel Bell from this morning.
Let's see, I'm Christopher Saxon.
I'm President.
She might still have the file up there. I don't know. Yeah, I was gonna urge a motion and she said she needs to talk to probation and I got the answer. from
All right,
probation.
on this, are you all agreed?
We're in agreement all along, exception of number 3.
And I can explain very briefly, Judge. My understanding, when I went back and talked to Mr. Saxon,
Mhm.
what he needs to do is the cell phone number he has apparently is technically on his ex-wife's account, and he's trying to take ownership of it, which she's fine with. But for them to be able to do that, he has to be in person, provide ID, they have to verify who he is because they're transferring ownership of a phone number from one person to another person. It's his number he's had forever. They just get him in person. It's a one-time thing. I wouldn't take more than an hour, but they said because they have to verify who he is and his identity and all that, that it's not something you can do like over the internet or the phone.
All right, so with regards to number 3, do you want to talk to the complainant? I don't know how this plan system is working.
I haven't, I can talk to her, Judge. I've been given, I get some time.
Oh, no, I mean, it's not going to be done today. All right.
But with regard to everything else, is that something we could revisit? Because some of the items on there are affecting his new job. And I think he's gonna go with his mother to Fort Sam tomorrow and whatnot.
Okay, so I'm removing 3.
Okay, very good.
So are you all in agreement and everything else?
Yes, Judge.
All right, so the court has removed 3. There you go. And if you want to approach on 3, you'll have to approach on 3 at another time.
We'll do that. Thank you. Thank you.
Okay, thank you. All right, so if I could, I'm gonna have everyone go to the back except for Mr. Morganfield. I'm gonna start jury selection on Morganfield. For everyone else who's scheduled for jury trial, you need to make sure that you leave your number because this case may go, it may not go. We're gonna see where we are.
And Judge, I don't think we have an election. I'm not sure.
All right, so Mr. Stevenson,
Yes, sir.
if your client were found guilty, who is he going to for punishment?
We've had discussions on that. I don't have an answer yet. I will try to get an answer very quickly. I understand that the default, no selection is made in judge. Is that correct?
Yes, that is correct. And Ms. Cutter, it's my understanding that Mr.
Rodriguez, Your Honor.
Rodriguez has hired you. This is a 5th setting case, so it's going to be going to trial.
Yes,
Either it's going to be going this week or either it's going to be going next week.
I don't know that I could represent him because I wouldn't have 10 days on that one, Your Honor, and I'm sorry, he called, and I apologize for my.
Oh, no.
No,
No.
I've never gone to court in slides before, but,
Yeah.
um,
No, I understand. And the reason why I didn't sign your motion as substitute, because I do realize that sometimes attorneys get hired on things and they don't realize what number settings it
Yes,
is.
yes, ma'am, that's correct. And so my office actually messed up. They were supposed to file it after today was handled to make sure that there was adequate time. However, if the court's saying go in 10 days, I'll make sure that we get it done, or whatever issues we have, I contact right away.
All right, so I will just make sure you leave your number with the clerk
Yes,
and we will get in touch with you and see how this trial goes.
yes, ma'am, I will do
All right,
that.
thank you.
Maybe.
Just leave your number.
I
and we'll
will.
call you back.
Will do.
Okay. And on Mr. Callahan? Denny Callahan. Denny Callahan. Hi. All right, Mr. Callahan, we're probably going to be able to get to your trial hopefully this week or next week, because there are a lot of people who have juries available, but then they don't need them. So just leave your number and we will give you a call.
I'll hang around for a few minutes, Judge.
All right, thank you.
I have my number right for
and Your Honor,
Jaden,
we're waiting
in
for
case,
some pre-trial
because you
services on
don't
a
leave
GPS
without
issue.
having her number.
Yes,
with you.
they can monitor him in Oklahoma, and I do have an email from Sentinel and from probation that been stating that.
That's on bail, correct?
Right.
Yes, ma'am.
Here you are.
Thank
And
you.
just take it to the back. So they can put it in the system. All right, and then that's done. All right, and Mr. Cox, yes, just leave your number and we're gonna give you all a call back.
All right.
And I need to see, on Morganfield, I need case number 1804. Hello.
Hello. I was gonna ask you this, today was my jury trial, but it was on vacation.
No, she needs to be here. So don't worry, we're gonna get in touch with her, but please hang around, okay? All right, thank you.
Over here. Okay.
Sure.
It's all right. I'll be on call. Well.
Gotta go to jury. He's eligible for probation if you go to jury.
I'm have Mr. Cox to leave his number.
Okay.
They went to go put the leg raise. So
Oh.
they're right back out.
You know, it's-
They'll be coming.
Couple of sheets of paper. You're all on.
Oh, sorry, Ben.
That's what I'm being told. I'm being told through the panel outside. Also. Big glass.
I'm assuming it's not yours, right?
Not mine.
All right, so state you're proceeding on each count.
Yes, there's all three counts.
All right, and it's the court's understanding that it's sexual assault of a child, is that correct?
One, two, three, or the child.
All right, let me pull the affidavit. I'm sorry, the indictment.
No, I should introduce my co-counsel. I call it yes.
Okay.
All right, so sexual assault and then indecency contact,
2 and 3 are decency.
contact, okay. Yes,
Normally has one cell phone number.
okay,
All four
Yes,
pieces make it
and we'll
just-
call you. Thank you.
Could have.
All right, what I'm gonna do is, I'm gonna have you go to the back, both of you. And we're gonna recall you for next week. So can you give them a next week setting on Tuesday?
Were you
Yes.
talking to me, Your Honor?
No.
I didn't understand.
Yeah, no. And so they need Tuesday of next week. What are their names? All right, we're gonna go on the record.
You want him out here?
Oh, he's
My-
not out there?
My,
Okay,
my co-counsel and I would like a couple of minutes to speak with my client. We do not have a probation application yet, and we do not have an election. We need a couple moments to speak with him in the back.
oh, they're gonna bring him out.
Okay. Okay. Couldn't have a seat. Here. Yeah. Everything. Not a jury waiver, you're signing an election punishment that if there is a guilty verdict, there's a possibility. Any trial can result in a guilty verdict. Or not guilty verdict. So if the jury does decide a guilty verdict, then the court needs to know the next step. You want to go to the judge who cannot be probation, or the jury who can. That's. Question that can be answered. Armstrong, right?
Who's your back?
Yeah.
I'm just fixing the cord.
Sorry.
Fine, just fixing the cord. So you want to flip and trip that. I'm looking after your safety.
Are your shoes tied? Are your shoes tied? Look, my shoe.
Yeah, one more time. Yeah, I guess.
That's so cute. No. I think bend it. And you have this. There was a few shoes in my face like. It was cute. Hold on. Judge, you want the people that were out here on hold, right?
Who's,
Mr. Watson?
yes, just hold them for a little bit because I want to see what happens here. And we only need to hold them for about 15 minutes.
The other thing.
I figured as much. One of the few good decisions. we made.
Brenda?
And then we had a juror who told them, any questions? And he's like, "Oh, if they ask me questions.
I mean, it's still possible.
Your shoes are tied.
Oh.
Because how much time are you asking for?
Like an hour, Judge. And punishment jury.
Okay, yeah, I'm sorry.
Finish up on-
And after Brenda does that, watch, this is, I don't think this is gonna go as long as, the voir dire, it's probably not gonna go as long as anticipated, but we should see. All right, and do we only have that one person? Deputy Laura, is it only that one person? All right, so where's the yes. Yeah.
I'm about to- No. Brenda, do you still hold it? Oh, yeah, sure.
Brenda, I guarantee you now that you've done that, we're gonna probably finish. Yeah.
Yeah.
This one is, yeah.
No, big. The big one.
Is she gonna be in here?
Yeah, we like her to be.
Okay, what are the chairs up for you? Like his mom. Or the area or somewhere else?
Wherever it's easiest for you all.
This end?
I mean, there's can be a seat here. If,
Your Honor,
yes,
we had pretrial motions that we would request be heard before the jury comes in. Some of them are not appropriate for the jury's listening.
and what is that?
We have-
And why are we waiting till the last moment to do that? Court is calling 2021 CR 1804 State of Texas versus Alexis Morganfield. That parties announced for the record for the state.
Michael Villarreal, County Resolve, States.
Ben Stevenson and Anthony Cantrell for the defendant.
All right, I've been informed that there is a juror that's missing, juror number 21. I've been told that juror number 1 has COVID. Any objections to that juror being excused?
The one with COVID, no
Yep.
objection.
All right, so juror number 21 is
This
excused.
is the one with COVID, you said, correct?
Yes.
Counsel, good.
All right. And what pretrial issues do you have?
Your Honor, I have all of my pre-trial motions in the order in which they were filed. I have a total of 12, and I would like to get each one on the record. They will be
If-
very quick.
Okay, if they're not related to this voir dire, then they're going to come after voir dire. So what do you have that's related to voir dire? Is there anything there that's related to voir dire that needs to be heard before jury selection?
Just look here. Mr. Cantrell? Question was, is there anything that needs to be heard for selection? I would like to research simply because I don't want to refer to. I want to each of them. Before, I think in the last 3. Okay. Your Honor, we are okay with running the first 9 motions
What,
after.
I understand, but what specifically are you saying needs to be heard?
I'm getting it wrong. We filed, which we believe needs to be heard before voir dire so that inappropriate statements are not made by the
What,
state.
what is the motion?
Defendant's opposition to state's notice of intent to present outcry statements, followed by motion to suppress outcry statements and motion to suppress recorded.
All right, state,
statements.
Good. The victim in this case is over 14 years old, so we don't anticipate offering an outcry witness.
okay, the state
Simply
says they're
like a
not,
ruling that there will not be any outcry statements or recorded statements that since she is over 18 years old and was over 16 at the time. of the
okay, I'm trying to figure out how this is affecting voir dire. State, are you planning on mentioning an outcry witness during your voir dire?
I don't plan on specifically asking about outcry witnesses, but I'm asking about witnesses generally.
I
We
don't-
wanted to make sure that everybody was on the same page, and since the alleged victim in this case is not under 14, that there not be any references to outcry or recorded statements of a named alleged victim to a forensic interviewer. We want to make sure that there's no mention of those in this case because
Well,
We need
I'm
those
just,
criteria.
here's the thing, I'm just focusing on you all during voir dire. That sounds like something that is for a jury trial when witnesses are called.
and I'll bring them up again. Your
Okay.
Honor, had I not mentioned something and had an inadvertent statement been made by the state, then I would have been remiss if I had not mentioned it before jury selection.
Okay,
So I'm assuming that we are on the record at this time, correct?
yes, we are on the record. Thank you. All right,
Anything else that we have can be after jury selection.
all right, let's bring the jurors in. And Mr. Stevenson,
Yes, Your Honor.
how much time are you asking for voir dire? The state is requesting an hour.
I think an hour will be adequate, Your Honor.
All right, and the way the court does voir dire is that each of you have an hour to do whatever you want to do with an hour, but that's your voir dire. Please do not come up with 60 witnesses, with 60 panel member asking me to hear them again. So.
I will
um,
promise not to waste the court's time, Your Honor.
No, I don't consider it a waste, but I just want everyone to understand in this court with regards to voir dire, you just ask whatever questions you want to ask. If you and the state can agree on some strikes, then let the court know. I usually follow those. And then if there's something else for a strike for cause, you don't have to strike for cause in front of the entire panel. We can do that afterwards, and I take notes. So I pretty much know where we are.
An hour for both general and individualized voir dire should be fine. We'll simply ask for maybe 5 to 10 minute warning.
Yes,
Thank you.
you're welcome. Oh, we're ready.
First row with Nance. Number 8. Your second row, first one on the top.
That one guy with the red one.
Oh, please have a seat. We're standing for you all. No, please be seated.
Oh.
That's what I'm saying.
Oh,
We're
sorry.
standing for you all. Have a seat. That's okay.
And you can get your number and make yourself comfortable. 30 to 30.
All right, everyone, please be seated. All right, everyone, good afternoon. Okay, that's like very low. Everybody's been talking low today for some reason. Good afternoon, everyone. All right, I'm Judge Stephanie Boyd. This is the 187 District Court. You are on the 4th floor and the 187 District Court with Judge Boyd. So who's the judge? Which floor?
4.
And what's the court number? I know you're probably asking yourself, why is she asking us that? Because we know where we are. It's because that when we're doing jury selection, everyone has to be in at the same time and be at the same location, which is the 187 District Court. And we've had it happen before where we've been waiting for someone and we're trying to figure out where that person is. And guess what? That person is down the hallway about to enter jury selection on another panel. And that's because this floor has courtrooms up and down it. So I want to make sure that when we all give you breaks, that you know where to come back. So what courtroom are you in? Thank you. She knows where I'm going. Fourth floor, and who's the judge? All right. The other person I want you to know is sitting to my right, and that is Brenna DeMoss. She is our court reporter. She's an excellent court reporter. She can actually take down 3 people talking at once, but we're not going to do that to her. So to help her make her job easier, what's going to end up happening is people are going to ask you questions. And when they do, if you want to respond to it, or you want to respond to something that's being said, you have in your possession something very valuable. Those are numbers. Could everyone lift their number for me? Okay, awesome. So when anybody wants to say something or respond, just lift that number and whoever is speaking will call on you. All right, I've introduced myself. I'm going to give the state a chance to introduce themselves. State.
Good afternoon, y'all. Michael Villarreal.
Good afternoon, Cassandra Rosales.
And for the defense.
Good afternoon. My name is Dan Stevenson.
Good afternoon, Anthony Cantrell for the defendant.
All right, and could you have your client introduce himself? All right, so all of those parties who've introduced themselves to you, does anyone know any of those parties? All right, other than meeting in the hallway or maybe downstairs, do any of you know each other other than just meeting for the first time? That is so strange. Usually we have school teachers who have students or somebody who works. We've had the wife and the ex-wife. They got along, so it was fine. All right. So I want to talk to you about the charge in this case. I'm just going to mention the charge, and then later I'll come back to you and ask you some questions about it. So the charge in this case is sexual assault of a child and indecency with a child by contact. Now, when the state and the defense, they're going to have a chance to speak with you. And when they speak with you, they're not going to be speaking about this specific case. They're going to be speaking about hypotheticals. Neither the state nor the defense nor myself are allowed to talk to you about any facts in this case. The only chance you will have to hear the facts in this case if you're selected to be on the jury. Does everyone understand? Yes. So anytime, just remember in the back of your mind, anytime the state is asking you questions, anytime the defense is asking you questions, they're speaking hypothetically about a case that is not this case. Now, sometimes you will see people coming through that door or through this door to speak with me. They're coming through that door because nobody reads the sign that says jury is in session, do not come through this door. They're coming through this door because even though we're trying this case, I still have other cases that are going on, and sometimes they need me to sign documents. But I want you to know it has absolutely nothing to do with this case. Does everyone understand?
Yes, ma'am.
Now I want to talk to you about an indictment and what an indictment means. How many people here have ever had any type of traffic ticket? Okay, so you need to practice raising your card. Some people were shy about it, didn't want people to know. So just raise your card. Now, I've had a traffic ticket before, and I don't know if you would have called it a traffic ticket. They said my window tint was too dark. So what ends up happening is when an officer pulls you over for a traffic ticket, and I think when I was growing up, it was, they gave you a ticket piece of paper. Now I think it's electronic. But when you get that traffic ticket, it's telling you what they believe you did, right? For example, if you ran a stop sign, the ticket's going to say you ran a stop sign. It'll give you a date telling you this is where you need to appear to address what we're saying you did. Does everyone understand that? Yes. So when you accept that traffic ticket, that's not an evidence of guilt. You're not saying you did it. You can still go to municipal court or wherever it may be to have a jury trial in that case. Does everyone understand?
Yes, sir.
So an indictment is not an evidence of guilt. An indictment is just in felony courts. There's an indictment, and guess what? It tells somebody who's accused of something, this is where we need you to be. This is what your charge is. And this is when your trial is going to take place. Does everyone understand?
Yes, sir.
So an indictment is not to be used as evidence of guilt. Is there anyone here who cannot follow that? Okay. Now, everyone has a right to remain silent. How many people have seen Beretta, Mannix? Okay, I know there are some people who, thank you. Thank you. Everybody else is pretending like they're too young to have seen that. Matlock, Perry Mason people, the practice. All right. So the right, everybody here, is there anyone here who hasn't heard of the right to remain silent? All right. So what that means is in criminal cases, no one can force you to testify against yourself. Does everyone understand? Now, if someone chooses to exercise their right to remain silent, you can't consider that or hold that against them as an evidence of guilt. Does everybody understand? You're not to consider it like Miss Kravitz in Bewitched. People always want to know what's happening over the fence. And it's okay to say, I wonder what's happening over the fence, but you can't bring it into any type of deliberations. Does everybody understand?
Yes.
So it's not an evidence of guilt. You're not to consider at all. Is there anyone who can't do that if someone were to decide not to testify? All right. Now, I want to talk to you about burden of proof. In criminal cases, the state must prove its case beyond a reasonable doubt. When I was in law school, there was a definition for proof beyond a reasonable doubt. I learned it backwards and forward. When I graduated in 1997, my first jury trial, I used it. My mom was so proud of me because I knew the definition. I was proud of me because I learned the definition. And guess what? The next case I tried, there was no longer a definition for proof beyond a reasonable doubt. So there is no definition of proof beyond a reasonable doubt. The state won't be able to give you a definition, and the defense won't be able to give you a definition. When I was a prosecutor and when I was a defense attorney, what I would do is tell people what it's not. So it is not preponderance of the evidence, which is sometimes what you see on the civil side. It is not clear and convincing evidence. Clear and convincing evidence is the proof you need in order to terminate someone's parental rights. Basically to say, we can't trust you with your children. We think you're a danger to your children. So we're not going to allow you to be a parent anymore. Proof beyond a reasonable doubt is a higher burden than that. Proof beyond a reasonable doubt is the highest burden. Does everyone understand?
Yes, ma'am.
And the state has the burden to prove their case. The defense doesn't have to prove anything. People will say the defense can be reading newspapers, do crosswords, puzzles. I personally, in my career, have never seen an attorney just sit there and ignore everything. But people use those as examples to let you know they don't have to prove anything. The state has the burden, and that burden never shifts, and everyone is presumed to be innocent unless and until the state proves its case beyond a reasonable doubt. Does everyone understand?
Yes.
So as you sit here today, you haven't received any evidence in this case. You don't know any facts of this case. So if you were asked to determine whether or not Mr. Morganfield were guilty or not guilty right now, your answer should be not guilty. Does everyone understand? And the reason why is because the state hasn't proven anything. Is there anyone who cannot follow that? Okay. Now, in a criminal case, there are two phases to the trial. First phase of a trial is whether somebody's guilty or not guilty. Somebody thinks it, sometimes people think it means, oh, it's innocence. No, it's either guilty or not guilty, because it's either the state proved this case beyond a reasonable doubt or they didn't. That's phase one. If you find somebody not guilty, then that's the end of it. If you were to find someone guilty, then there's a phase two in Texas, and that's called the punishment phase. And that's where you determine what type of punishment someone should receive. Does everybody understand? Now, when people talk to you about ranges of punishment, they will say, oh, the range of punishment is 2 to 20 years or probation. Here's the thing about that. Nobody is asking you, would you give someone 20 years if you were to find them guilty of this type of offense, or would you give them probation? Nobody's asking you what you would give them if you were to find someone guilty, because you don't have any evidence to make that determination. Does everybody understand? So what people will be asking for is if you could consider it. Not that you give it, but you consider it. Like, for example, range of punishment, potentially probation, range of punishment, 2 to 20 years. So is there anyone here who could not consider the full range of punishment? All right. Now, the next thing I want to talk to you about is something called the one witness rule. I'm going to give you a fact scenario, a hypothetical. Do not add to the hypothetical, okay? Don't ask, well, were they wearing glasses like I am? What's their vision? Is it light out? Is it dark out? Don't bring any of that into the fact scenario. So here's the fact scenario / hypothetical I'm going to give you. A witness is called to testify. You listen to that witness. You believe that witness. There's no issue about their credibility. It could be Mother Teresa. It could be someone's mom, whoever it may be. It's just somebody you find them credible, and you believe everything that they're saying on the witness stand. And that one person proves the state's case beyond a reasonable doubt. Does everyone else follow the fact scenario? So what that would mean is that one witness that you believe has ticked off every box that the state needs to prove beyond a reasonable doubt. Would you be able to find someone guilty with one witness? And I'm not talking about this case. Remember, it's hypothetical. And remember, it's one witness. You believe that one witness. There's no issue about whether it was dark out, whether they could see. You 100% believe them. You believe them beyond a reasonable doubt. Does everyone understand the hypothetical? All right. Is there anyone who would not be able to find someone guilty if there were one witness in a case and it proves the state's case beyond a reasonable doubt? Okay. Okay. The other question I'm going to ask you is, and I always stumble on how to ask this question, because if there's someone here who doesn't speak English, they don't understand what I'm saying. So I'm going to ask it this way. Is there anyone here who English is not your first language? Okay. And just keep your card up, please. And so when I ask you all questions, and when the state and the defense ask you questions, if you're over here in the box, you don't need to stand because Brenna will be able to hear you. If you're first on this row, you don't need to stand. Brenna will be able to hear you. But everybody else who's not on these 3 rows, when you speak, you'll need to stand if you can so that Brenna can hear you. All right, juror number 35.
Yes.
What is your first language?
Spanish.
Spanish. All right, have you been able to understand everything that's been said? All right, thank you. I think all the languages are beautiful, by the way. All right, who else? Number 50.
My language is Spanish, the second one Italian, and the third one.
Okay, can you speak up a little bit because Brenda didn't get all of that?
Okay, my first one is Spanish. Second one Italian, and the third one English.
Oh, that is so fabulous.
Okay.
Thank you. Have you been able to understand everything that's been said?
Yes.
All right, thank you. And number 72.
Hello, my name is Nicole. My first language is Spanish.
All right, and have you been able to understand everything?
Yes.
All right, is there anyone else? All right, the other question I'm going to ask you, is there anyone with time constraints? Now, what do I mean by time constraints? I mean, you have booked a flight, the tickets are non-refundable, you can't give them to me, I can't go in your place. So is there anyone who has that situation? All right, number 5.
Yes, ma'am.
Yes, where are you going?
My wife graduates Friday. She's getting her second master's degree. We're going to Texas A&M Commerce on Friday. I mean, if it's between today and Thursday, I'm fine. But Friday, we're leaving town.
All right, does she want you there with her?
I'm the one that's driving her there.
Okay, so your necessity is not that she may not want you there, but she needs you there.
Well, my benefits are paid for her college. I'm a veteran.
Okay.
My military benefits are paid for her college.
Okay, all right, thank you. Anyone else? Number 55.
I can't hear you, ma'am.
All right, what are you doing in El Paso? All right, how old is the baby? How old is the baby? Ah, she's not even gonna remember. Okay, all right, thank you. 69. All right, and where are you going to school?
He goes to school at,
Okay, and where are you going? I'm sorry, the last part trailed off. Okay. And I know you have to travel with your 9-year-old, but does he want you there? Okay. All right, and you're leaving tomorrow? Okay. All right, thank you. Is there anyone else with any number one?
Yes, I'm driving to El Paso. I'm going with my grandparents. We have some family out there and they're not really able to drive out there, so I need to drive.
Are you going with number 55 to share on the gas? Okay. All right, who else? 68.
Waiting on my son's in Great Lakes, the naval base, and he's waiting for his evaluation from the petty officer. And between now and Thursday, we're supposed to speak to the conference.
Okay, so what is your role on the conference call?
Father,
Okay, and what time is the conference call? They never tell you that. Okay, all right, thanks. Anyone else? Number 56.
No, I have to testify in a custody at the end of the month, so I don't know how long.
All right, thank you. Any 25?
I just wanted to say, I don't know how long it lasts either, but I do have surgery scheduled for August 26th.
Okay. Thank you. What type of surgery? If you don't mind sharing.
It's a hernia surgery.
Okay, I know that can be painful.
Yeah, I just don't know how long that'll last either.
All right, thank you. Number 7.
Yeah, I have appointments for next week, not this week. 15th and the 17th, week after 22nd and 24th.
All right, and what are those appointments for?
with the VA.
Okay. Well, you know, once you get those appointments, you don't want to lose them, right?
I'm really hard of hearing too, man.
Oh, I said, once you get those appointments, you don't want to lose them.
Oh, no.
Okay.
No.
All right.
You go to the end of the line and start again.
Oh, yes, I know about that. Number 30.
Yeah, my daughter has wisdom teeth extraction on 16th.
August 16th.
Yes. Just don't know how long.
Okay. She may not want you there because she may not want to do it, but she's going to need you there.
Yeah, I could try.
Okay. 65.
Yes, my daughter has
All right. Thank you for letting us know. Yes, 43.
Friday, August 26th, my wife is flying with our son to take him to college.
Mhm.
So I will need to stay behind and talk to our younger kids,
And how old are your younger kids?
12 and 3.
But how else are they going to have a chance to break rules? If they're supervised, okay. And what college is your son going to? Oh, wow. All right, that'll be a nice trip. All right, anyone else? Number 12.
I'm the driver for my granddaughter. She's a heart transplant.
Mhm.
She's 18 months, she's in her week, but we go to August on the 12th for a bone, we measure her age. And
Okay.
on the 17th, we go to Austin for that echo.
Okay. All right, thanks for letting me know. Okay, I think that is number 61.
started school for teaching, so I'm missing all the staff development and lockdown procedures and safety procedures right now, so. Set up a classroom, get some new.
All right, All right. No, it's fine. I mean, everyone is telling me where they need to be, but this is just me giving information for the state and the defense. 34.
I don't know if this counts too, but my semester starts on the 22nd.
Where are you in school? What are you studying?
Computer science,
Okay. And when does school start?
the 22nd.
It does for me as well. So I have to get my lesson plan together for my students at UTSA, but okay, thank you. Number 32.
Yes, ma'am, I have a doctor appointment 2:30 to 11 this Thursday. Respiratory.
Okay. All right, thank you so much. All right, so my next question, is there anyone who, well, strike that. Let me just make sure I have everything. All right, so I told you all that we're going to be speaking in hypotheticals, but I'm going to tell you 2 true stories. The first one is concerning my uncle. My uncle was from Grand Canyon, Louisiana. He's since passed. Super intelligent. The teachers used to skip him ahead grades. That's how intelligent he was. So they started the military draft, and they were drafting all of the young boys from Grand Canyon. So he was like, I'm not going to be picking cotton. I'm not going to be a sharecropper. I'm not doing that. So instead of waiting to be drafted, he just enlisted into the Army, and he went to serve off in war. I tell that story because our country, people say, oh, it's the best country in the world. It's the best justice system in the world. None of it can work unless we have jurors. And the country really doesn't ask that much of us. What do they ask for? They ask that you show up for jury duty. There's not even a draft unless, they change the laws. You don't even get drafted anymore. You'll be sent to join the military if you voluntarily decide to go to the military, or you voluntarily decide to go and enter a war. But that's all they ask of you. They don't even ask you to vote. So this is one of the ways that you serve your country, by agreeing to be on a jury. And we cannot have jury trials if we don't have jurors for jury trials. So my uncle has since passed, but he would always show up for jury duty, and he went off to fight a war, even though he was young, and my grandmother had to sign for him to go. The second true story I'm going to tell you is about one of my friends from law school. She decided to practice civil law. And I know the civil attorneys are going to get upset for me for saying this, but usually the attorneys who are always in court as far as jury trials usually happens on the criminal side. And she didn't really get a chance to do a lot of trials. So we hadn't seen each other for a while. And she said, Stephanie, I've been called up for jury duty. Let's have lunch. And I said, great, let's do it. So at her break, we have lunch. And I asked her, how is your service going? And she's like, it's going fantastic. Now, mind you, I think jury duty is fantastic, but I just never heard anyone describe it that way. So I'm like, why are you saying that? She's like, I'm not going to get selected. I'm like, how do you know you're not going to get selected? She said, it's just like when we were in law school. I'm on the back row, keeping my head down, avoiding conversations. So I started laughing hysterically, and I couldn't stop laughing. And she said, what's so funny? I said, you're going to be on that jury because you're keeping your head down. You're not saying anything. She's like, yeah, right. So at the close of business day, I wait for her. At 5:30 p.m., I'm like, hey, how's jury duty going? She's like, how did you know I was going to be on the jury panel? I'm like, because you kept your head down and you didn't say anything. So with that being said, I am going to turn it over to the state for their presentation, and then I'll turn it over to the defense. State, are you ready to proceed?
Yes, sir. Thank you. Good afternoon, everybody. Now that judge has y'all warmed up and ready to talk, especially that last part of the speech, right? So again, my name is Michael Villarreal, along with my partner Kathy Rosales. We represent the state. So I use a lot of visual aids in my presentation, and so all of it should be projected up here for you, for a lot of things that we've been talking about. So, who, when they got their jury card in the mail, thought this? Right? Especially who thought this now that they hear that there might be sitting on a jury for a sexual assault of a child and indecency with a child. Right? Pretty solemn, right? So, a lot of, not surprisingly, we don't get this reaction very much, but we appreciate all of y'all being here. So what I'd like to start about with is, what is the purpose of voir dire or jury selection? And I like to think about it in this way. Who knows who this is? See some cards up. I hear generally Willie, right? Our beloved Texan. What does Willie Nelson love? Hint is in the picture. Marijuana, right? Willie loves weed. I think he even smoked pot on top of the White House. Is Willie Nelson going to be a good juror on the possession of marijuana case? No, right? Because he doesn't agree with our laws, right? He says, I understand them, but I just don't agree with them. I'm not going to follow them, right? This is the one time where you get to argue with a lawyer, or state your opinion to a lawyer and a judge. We're not going to argue back. So don't try this with your spouses or loved ones. We just need to know what your opinion is about the law, how you feel about the law, whether you understand the law, whether you can follow the law. It's okay if you cannot follow the law. It's just that we as a state and the defense need to know that. So I'm going to refer to this as the Willie rule. Okay. So is Willie Nelson necessarily going to be a bad juror for a murder case? No, right? For an assault case, right? No indication that he cannot follow that law. It's just we need to know if you disagree with the law and if you cannot follow the law. Okay. Some people are like more like my older brother who are very like mathy. I don't know, put it the other way. Deal with numbers. So some people like equations. So what is a fair and impartial juror? It is you are able to follow the law that the judge is going to give you at the end of the case. So you don't need to know the law, the judge is going to provide it to you. And that you are going to base your decisions about only the facts and the evidence from you here in this case. So that's what makes a fair and impartial juror. Judge talked about this briefly. This is the state's burden in all criminal cases. It is beyond a reasonable doubt. Like the judge told you, there used to be a definition. That definition no longer exists. So neither I nor the defense can tell you what beyond a reasonable doubt is, what that means. We can tell you what it doesn't mean in certain circumstances. It doesn't mean it is proof beyond all doubt, right? It's proof beyond a reasonable doubt. It does not mean 100%. And it possible does not always mean reasonable, right? Is it possible that you had a twin at birth that was taken by some evil person and I don't know, created some type of monster and then caused them to commit this crime, look like you? I guess. Doesn't mean is it reasonable? No. So you have to look at whether each element, whether you have a reasonable doubt as to it. And reasonable doubt, it only applies to the elements of the offense. Okay. So if you have a reasonable doubt that a witness was wearing a blue shirt versus a red shirt one day, and so long as you believe each and every other element beyond a reasonable doubt, or each element beyond a reasonable doubt, that is a guilty verdict, right? You can have a reasonable doubt so long as it doesn't go to the elements of the offense. And we'll talk about the elements in just a second. Does that make sense to everybody? Right? There might be some reasonable doubts about whether it was rainy or sunny, but as long as it doesn't apply to one of the elements, then we have met our burden. So I like to use this to help illustrate beyond a reasonable doubt. Who here has dogs? You see a lot of cards. I don't think I need your attention. Have you ever come home to something like this? No. No? Okay. Who has dogs who's come home to something like this? They're number 3. Okay, tell me what happened.
They
they got to the trash and poured all over the house.
Okay. Pretty sure you're not happy when you get home, right? Were you there to see it happen?
Yeah.
Okay, but you know beyond a reasonable doubt that the dog did it, right? So this just helps to go show that you don't have to be there to know something happened beyond a reasonable doubt, right? Because if you knew something happened, you would be a witness in this case, right? And you would be taking the stand and testifying. You wouldn't be deciding whether the state has met its burden. Does that make sense to everybody?
Yes.
Does anybody have questions about the state's burden? So there's 3 counts in this indictment. And so we're going to talk about all 3 counts. So the first count is what the judge mentioned is sexual assault of a child. And these are the elements that they have to prove to you beyond a reasonable doubt. That on or about March 29th, 2020, Alexis Morganfield, the defendant, intentionally or knowingly penetrated the mouth of Sarah Fundrianu, a child younger than the age of 17, with the defendant's sexual organ. Well, most of these, and we'll talk about this on the next 2 slides, most of these are not going to be contested issues necessarily. And so I'm not going to spend a lot of time about on or about a date, the defendant, the victim, whether the victim's a child or not. But some of these might be a little bit more contested, so we'll break those down in just a second. Count 2 is an indecency with the child. It's on or about the same date. Alexis Morganfield is the defendant intentionally or knowingly engaged in sexual contact with Sarah Fundrianu, a child, by touching part of her genitals with the intent to arouse or gratify the sexual desire of any person. And then the third count is the same thing except for it's touching of the breast. So you can see there's kind of a lot of carryover in a lot of these elements. And so one of those is the state's, let's say it's the mental state. And that is whether something happened intentionally or knowingly. So this is how our code defines these 2 definitions. Intentionally is your conscious objective or desire to engage in the conduct or cause the result. Knowingly is aware that the conduct is reasonably certain to cause the result. So I think these are, although they're written very technically, I think we kind of generally know what these things are. So if I grab my clicker, I look at Cassie and I'm mad at her for some reason, and I throw it at her and it hits her. Is it fair to say that it is my objective or desire to hit her with the clicker? Right? I'm not saying, hey, Cassie, I'm intending to hit you with this clicker and then throwing it at her, right? And knowingly, so we're looking at the result on a knowing, whether I know the result will happen when I throw it at her. I might not necessarily intend to, but me throwing it at her, I know it's going to hit her and cause that result. That makes sense to everybody? Yes. So when you saw on those slides, it said intentionally or knowingly. So the state only has to prove to you at least just one of them. So if you were to make this jury and 4 of you said, I think it was just intentionally. And then the next 4 say, well, I think it was just knowingly. And then the last 4 say, well, I think it was both. So long as you found one of them beyond a reasonable doubt, then the state has met its burden, right? You don't all have to agree that it was all intentionally, all knowingly, or all both. You just have to agree that at least one of them exists. The state has met its burden. Okay? Does anybody have any questions about that? How do we know someone acted intentionally or knowingly? Anybody? Remember what the judge said? I'm sorry, remember,
Hard to understand what you hear now.
okay,
Doing that there.
okay.
Can you repeat that? I'm sorry.
Yes, it's kind of hard to know if you were not there to see.
If they admitted it.
They admitted it, right? So, turn number 30, if you can stand for me, sorry. Joe since it's planning, okay. Using my example with Cassie, right? You have to look at the facts and the circumstances surrounding the offense to know whether it happened intentionally or knowing, right? Because y'all are, I'm assuming, I looked at every single one of your occupations. I did not see mind reader on any of them or psychic. You don't know what's necessarily going on in someone's head. They're not necessarily going to say, I intend to do this. there might not be a plan or preparation, right? It might just happen in the instant. But you have to look at the surrounding facts to make that determination. Right, because like the judge talked about, you might not hear what's going on in the defendant's head because he has the right to remain silent. And so you might not hear anything from them. That is his right, okay? So in looking at all through those elements, I want to point out some things that the state does not have. The state does not have to prove that the defendant knew the age of the child. Okay. Does that make sense to everybody? Any questions about that? Okay. Right. I don't have to show that he necessarily knew that the child was 12. He knew that the child was 15. I have to show that he intentionally or knowingly engaged in that conduct and that it was against a child that was 17 years or younger than 17. Not 17, younger than 17. Is that a problem for anybody? Okay. If yours, yes.
I sponsored a military court martial.
Okay.
For my stepdaughter, underage, under 17. They had a guilty verdict. And then first married into my family.
Okay.
And then I got divorced.
Okay.
What did you say?
And then they got divorced. That's all I said. Does anybody have a problem with that? That the state does not have to prove that? Number 36.
My question is.
If you could stand for me for Brenna, I'm sorry.
You talk about intentionality. And knowingly, if they thought the person was an adult. It seems to be that that person who committed the crime would have to have something in their mind that they weren't an adult at the time. They wouldn't know they were committing a crime.
And so maybe I didn't explain this well enough. So I apologize for that. We have to show that they intentionally know that engaged in the conduct, like when we said the elements penetrating her mouth with his sexual organ. I have to show that that was intentionally or knowingly, right? I don't have to show that he intentionally or knowingly did it to a child, right? That he knew that the defendant's knowledge about the age, and this is our law. It's one of those willing rules. If you disagree with the law, I just need to know it. We don't have to necessarily prove that he knew that it was a person under the age of 17. Juror number, right, yeah. Juror number 3, 52, 42, 67. I got 3, right? Did I miss anything? Kind of on a similar strain. Does the age of the child compared to the age of the defendant matter to you as a juror for purposes of determining whether he is guilty or not guilty? I'm not talking about potentially punishment, but the age difference. Does that matter in determining whether he is guilty or not guilty? Without affecting him? Okay. Juror numbers 3, 1, 8, 10, 15, 16, 18, 19, 20, 23, 24, 25, 28, 30, 37, 40, 42, 29, 47, 49, 52, 56, 58, 61, 62, 63, 65, 67, and 69, 31. Did I miss anything? Okay. Out of all those that raise their cards, what I'm saying is not necessarily it would affect whether you would give him whatever for punishment. But this would affect whether you could find him guilty or not guilty. Does that change anybody's mind that raised their cards? Yeah.
Is the charge about consent or is it because of age?
That's something that the state does not have to prove. If you saw that because it is a child case, the state does not have to prove that there was a lack of consent. this might more like colloquially known as like statutory rape people think of, right? When it's just the age that makes it an offense. Okay. That answer your question? Okay. All right, so let's talk about witnesses for a second. In this scenario, you have to get robbed. Sorry. There's not a choice of if you, I'd rather not get robbed. Who would rather be robbed in the picture on the left versus the picture on the right? I'm not seeing any cards, right? Why would you want to get, if you had to get robbed, you know, nobody wants to get robbed. Why would you want to get robbed in the picture on the right? That'd be open, sorry.
Witnesses.
Juror number 20, more witnesses, right? I'm an Aggie, so I know it's Memorial Stadium. But still, I think it holds 100,000 people, right? I would want 100,000 people to be able to be witnesses to it. Is that a reality of how crimes happen? Especially if we talk about what we're talking about here today, sexual assault of children and indecent of a child. Do you think there's a lot of witnesses necessarily on those cases? Why is that? If you could raise your cards for me. Juror number 53, you could stand for me too.
Oh, stand up?
Yes,
Oh, well, because you don't want anyone to know what's happening.
right? Thank you. Juror number 3.
It's a private act.
Right, it's a private act, right? A lot of these things are not happening out in the open. So here's another hypothetical. So you're leaving after jury selection here today. You're distraught because you didn't make the jury. This is truly a hypothetical. So you're going to your car. You were lucky enough, you got here early enough where you actually got to park into the garage. You're heading to your car and somebody mugs you. They rob you for what you have on you. This is Bear County, so the cameras are not going to work in any of the garage. So you cannot rely on a camera or any video. You're in the garage alone. There's no other witnesses. Who thinks that the state should not proceed on that case? I don't see any cards, right? Why is that? It's the easy question. Right, crime was committed, right? Does not having any witnesses mean that a crime did not happen? No. So this is a scaled question that I get to get a little snapshot of each one of you really quickly. And so you have to pick one of the four, whichever of the four that you both strongly agree with the answer on, okay? So the question is that if only one person testifies, that is not enough to find someone guilty. One is strongly disagree. One witness is enough if believable. 2 is disagree. I will decide based on the testimony. 3 is agree. I want more. 4 is strongly agree. I need more. So again, the question is, if only one person testifies, that is enough to find someone guilty. Who falls into category number 1? Strongly disagree. One witness is enough if believable. You could raise your cards for me. I see 8, 7, 13, 24, 18, 26, 29, 31, 3, 14, 37, 43, 44, 45, 48, 49, 52, 53, 58, 61, 66, and 69. Did I miss anybody? Who falls into category number 2? Disagree. I see 2, 6, 9, 11, 12, 15, 16, 17, 19, 20, 22, 23, 25, 30, 32, 33, 34, 36, 38, 39, 40, 46, 51, 54, 55, 56, 59, 60, 65, 70, 71, 72, 73, 74, and 75. Who falls into category number 3? Agree, I want more. Okay, I see 1, 4, 5, 10, 28, 27 is your card up, 27, 35, 41, 42, 47, 50, 62, 63, 64, and 67. And then who falls into category number 4? Strongly agree, I need more. Emily? Yes. Yes, ma'am.
I wanted to go with 2 and not.
Okay, and what's your number? Are you 53? You want to be number 2, not number 1. Thank you. Let's get that one. So obviously, based on what we're here for today, what we talked about the elements, our case involved children. So who here has kids? A lot of cards up. God bless all of you. I am not fortunate enough to have kids yet. Who can raise your cards again? Who here has young children? All right, we go with juror number 4 for a little bit. Your kids go to school? Okay. Who here has kids young enough to go to school at least? I'll go with number 5. So you get to see your kids when they come home from school?
Yes.
You ask them about their day? Okay. When they tell you about their day, do they go from start to finish? Like how, in chronological order?
They just walk in the room and ignore me.
I had a cat.
Well, they're
Same thing.
teenagers, so it's like they don't want to talk about it.
They don't want to talk about it. If you ask them about their day though, do they go from, well, I got, I went to school at this time. My first period was this. My second period was this. Okay. What do they generally talk to you about? If they talk to you?
When they're hungry, they want money, they want video games, new computer, stuff like that.
Okay.
Complaints.
A lot of complaints, I'm sure. But when they're talking about their day, do they necessarily talk about it in order?
Don't.
Okay. Okay, who here has kids that will talk about their day? You're number 4.
They talk about their most exciting things.
Right. Are they going to talk about necessarily, if breakfast wasn't exciting, are they going to talk about breakfast?
No.
Are they going to talk about like their least favorite subject necessarily?
No.
Are they necessarily the best historians in talking about things as they happen in order? Are they going to tell you every detail that happened that day?
No.
In the details they give you, do they sometimes might change a little bit if you ask them about it again?
Yeah.
Does that mean they're necessarily lying about what happened?
No.
Sometimes they
They
might.
have an imagination.
Right. I mean, I think we all can agree. Raise your cards if kids lie. Right? When kids lie, though, generally, do they lie to get out of trouble or to get in trouble? Right? So they might make up something like, I didn't take that toy, or I didn't hit so-and-so, right? Are they gonna make up a lie to get just somebody else in trouble, just to get them into trouble? Sometimes, right? So kind of following on this is, if you were to make this jury, the judge is going to instruct you that you are the judges of the credibility of the witnesses, and you would determine the weight to be given to their testimony. So you kind of have a couple options when you hear witnesses. You can believe everything of what they say. You can believe nothing of what they can say or what they said, or you can believe some and not believe other parts, right? You can give a little bit of each. So we make judgment calls about people's credibility probably every day, whether we want to agree or not. So what types of things do you look at when you're determining the credibility of a witness? Or a person, any person you interact with? Juror number 33, you can see it for me?
Consistency in
Con-
the story.
Consistency, okay. Juror number 3,
Past reputation.
past reputation. Anybody else? Juror number 62,
Body language.
body language. Juror number 18,
Their eyes,
eyes,
they look.
okay. Anybody else? So these are some of the responses I've gotten for. Demeanor, I think juror number 62 might have kind of touched on this, body language, how are they acting, how are they reacting, right? What's their demeanor like? I think it's a big one that nobody touched on necessarily. Motive. Do they have a dog in the fight? Do they have a reason to be saying something one way or another? Right? Is saying something might get them out of trouble, saying something, get them in less trouble. What they say, just generally, does it pass the smell test? Does it make any sense what they're saying? And I think, who was it? Talk about consistency. Juror number 33. Talk about consistency. Does inconsistency necessarily mean that somebody is not telling the truth? No. So I'll give you kind of two examples. Who here likes to watch college football, professional football? Right? Okay. So let's take it from three different perspectives. A ref, a player, and a spectator, right? Somebody who's watching the game. Do you think that they're all going to be able to tell you from their point of view the exact same thing about something that happened, a play on the game? Right?
No.
No. Does that mean that all of them weren't necessarily there watching the same game? Right? There's a lot of people watching the same game too, right? Not what they saw. So again, it might change depending on their point of view, their perception. Maybe they have something biased going in towards the game. If your team is playing right, you might not want to see a penalty, right? Also, maybe there's been some time elapsed since you saw it. I like to also think about this in a more San Antonio terms as it relates to Fiesta. Who has been to any of the parades here in San Antonio? You see a lot of cars. So my aunt and uncle used to take me to Battle of Flowers every single year. And I was a fat kid growing up. So it was one of my favorite things because on the way, we'd always go pick up Church's chicken and it was one of the exciting parts of my day. So I have a very vivid memory of a lot of yes, a lot of Battle of Flowers parades. So let's say I go to the Battle of Flowers parade. I watch all of it. I see all the floats. I get to see all the duchesses and their shoes and all the bands that play. Do you think necessarily, even right after the parade, I'd be able to tell you the order of the floats? Right. So let's say I do tell you, I remember these particular floats. I'm always gonna remember the A&M band, and maybe some of the Duchess's shoes. So I tell you right after the parade, these are the floats that I saw. This is the order that I saw them in. These are the bands that I saw. If I talk about that same parade, let's say 6 months later, do you think I'm going to be able to give you those same details? Probably not, right? Might I get the order right? Maybe, probably not. Does it mean that I didn't go to that parade? Right? So there's a lot of factors that affect necessarily consistency, but don't necessarily mean that people are lying or being untruthful. Does that make sense to everybody? Does anybody disagree? Number 5?
Well, I think you're gonna remember what happened at the beginning more than what happened at the end. Primacy and recency.
Very good. We use that a lot in our field. Are you talking about the actual parade or when I'm telling the story?
The parade, you're gonna remember the first floats and you might remember the last one. You're gonna forget a lot of the stuff in the middle.
right? That might be true, but I might remember just the A&M band, right? Because that's what I'm looking for. I think there's a lot of factors go in there, right? Juror number 29.
A lot of times. I listen to the people's tone when you speak.
Yeah.
You can tell if somebody's angry, somebody's happy. But there's tone of the voice. And I've come from some of my coworkers. Are you angry? Why? Because your tone, I'm not really strong. And if I did something. Thank you. I'm sorry.
So when you're talking about credibility witnesses, tone might matter to you, right? The tone of their voice.
Yes.
Okay, perfect. Thank you. So I want to talk about demeanor, especially as it relates to child sex cases. Is there any volunteers who would like to tell me, in front of your new 74 best friends, your first sexual experience? Do you have any volunteers? No, right? I sure, I mean, I don't want to hear it either. No offense. But do you think these are comfortable situations for child victims to come in here and tell a lot of times what is their first sexual experience? Right? Do we expect them to act or testify in a certain way? And if you do, that's okay. Is it fair to say that a lot of people react to trauma in different ways? Right. Is there any I expect a child or a victim to act this way or have this characteristic when coming in here and testifying?
You say it again.
Like I expect a child to have this certain characteristic or demeanor when coming in here and testifying. Juror number 19.
You're a little frightened.
Frightened, right? They might be frightened. Juror number 28.
You're not going to be overexcited to be here. It's, like a pretty, if they're here, that means that they are, like serious about it.
Okay. Juror number 5.
Their anxiety levels will go up when they see the person that did what they did.
Right. Juror number 1.
They might get frightened just of speaking of what happened in front of all these people. So like going back to one of the other slides, their story might get mixed up.
Okay. Juror number 29.
They might not even want to talk about.
Right? It might bring up a lot of emotions. They might get trouble. Anybody here know any nervous laughers? Right. So kind of going back to juror number 28. Sometimes you might see some reactions that you think are happy or sad, or you might read them in one way, but they might not actually be good things. I have a brother who's like that. And it's terrible. He gets like the worst case of the giggle every time he gets interrogated. Please don't ever get in trouble, because if the cops talk to you, you're gonna be in trouble. Okay. So are all child abuse victims the same?
No.
React the same?
No.
Look the same?
No.
Testify the same way? Do we expect that?
No.
So I like to use this slide to illustrate kind of the variety. These are well-known people who are victims or said that they are victims of child abuse. We see Oprah Winfrey. Oh my God, why is his name blank?
Tyler Perry.
Tyler Perry. Ellen DeGeneres. Carlos Santana. America Ferrera. Axl Rose. Ooh. Let's see if anybody knows who this one is.
Axl Rose.
No, this next one. Rita Hayworth, right? Okay. I know mostly from Shawshank Redemption. Mike Tyson. Right? It's sorry, the picture's small. It's Mike Tyson. All of these people, they look the same to you. They all sound the same to you. Definitely, I can probably say a lot of them had different upbringings, different trajectories in their life, but nonetheless, they're still all victims of child abuse. We already talked about that one. So next we're gonna talk about is evidence in these types of cases. So first thing I want you to know is that testimony is evidence. So a lot of what you're going to expect that you're going to hear in these type of cases or any criminal case is testimony. Witnesses are going to take the stand, they're going to take a note, and they're going to tell what happened. So all of that is evidence in these cases. Again, you get to determine the credibility of them and the weight to be given their testimony, to whether you believe it or don't believe it. Nevertheless, it's still evidence for you to consider. What type or kind of evidence would you expect in these types of cases? Juror number 72.
Testimony.
Good one. Juror number 33. Medical. Juror number 3.
Admission.
Admission. Anything else? Juror number 28.
Social media or like texts and things like that.
Okay, thank you. Juror number 38. You can stand for me.
Psychological.
Okay, psychological. Anybody else? Juror number 2.
Objects used.
Objects used. Okay. So, things are pretty common things that we might expect from jurors, like photos, video, other witnesses. Is there anybody here that says, I need to see a particular piece of evidence other than testimony? There's a particular piece of evidence in order to find someone guilty of this offense. That is like, I would have to see medical records in order to find somebody guilty of this offense. Or I would have to see photographs in order to find somebody guilty of this offense. If anybody feels that way about any particular piece of evidence. Juror number 67. If you could stand for me, I'm sorry. Okay. Thank you. Anybody else? Juror number 5.
DNA evidence.
You would have to see DNA evidence.
Well, that would help. What the evidence.
And this is, we all want DNA, we all want fingerprints, we all want confessions. This is saying I would have to see this in order to find somebody guilty. You would like to see DNA evidence, but would you require it?
Depends on the other evidence.
Okay. Anybody else? Juror number 36.
I feel like in a way, just one witness, it's just, it could be just hearsay. If we don't have anything else to back up what happened or another witness, I think it would be hard to find the person guilty based on one person's evidence.
Okay. Anybody agree with 36? I see 5, 8, 23, 42, 38, 52, 47, 57, 58, 67, 71, 72, 26, and 32. Now, we'll talk about what juror number 5 talked about, medical evidence or DNA evidence. You saw what the state is having to prove in this case. So part of these are indecency, so there's touchings. And part of it was count 1 was a sexual assault, so penetrating the mouth with the defendant's sexual organ. Does anyone expect medical evidence in a touching case? So there's 2 second counts. Do they I see maybe a card? No, okay. Does anybody expect medical exam? Okay. DNA. 17. Why might you not hear any medical evidence? Juror number 33. Time frame, okay. Anybody else? 53, you could stand for me.
Okay, you're going to take the child to the doctor, they said someone touched them. I mean, that could be
Okay,
medical.
thank you. Juror number 30, you can see it for me,
I can't see you or hear you.
if you can see it, I'm sorry.
Person's interview with your sexual organ. Now, you can't do it.
Okay. Juror number 29,
I agree with the time frame.
time frame. Anybody else? Right? Fair to say, you might not hear any medical evidence because medical evidence doesn't exist in these cases, in some cases, right? Is that fair to say? I think juror number 28 or 33 talked about this, right? You might have a delayed outcry. They didn't tell for a while, and so any evidence that the state would have is no longer there. Right? Maybe the facts don't lend themselves to the necessity of a medical exam or collection of evidence, right? Thinking about, just some touching case. I think juror number 30, I believe, said that touching cases, you're penetrating the mouth, you're just not going to get that type of evidence, right? So they might not be necessary. Is there anybody here who would need to hear medical evidence in order to find somebody guilty of this crime? Or these two offenses? I would need to hear it. Nobody? The next thing I'll talk about is punishment. So if you were, the first stage of the trial again is the guilt innocence, and that is whether the state has met its burden as far as those elements are concerned. If you found him guilty, then we would move on to the second phase of punishment where you would determine his punishment. So the range of punishment for all of these is 2 to 20 years, up to a $10,000 fine, both fine and confinement. Probation is a possibility based on the offense, and so long as the sentence is less than 10 years. Just give you an example about whether you can consider the full range of punishment. I like to think about it in this way. So I'm a mama's boy, not very shockingly, and I have before the pandemic started, I had a standing lunch date with my mother every Saturday at China Inn, because that's my favorite Chinese restaurant. And so we'd be there every Saturday. I would go in there and I would still ask for a menu, even though I knew exactly what I was going to order. I'm going to order Kung Pao chicken. I'm sorry, that has to go on the record. She's like, I don't have a keystroke for that. Extra peppers and fried rice, right? What I like to think about range of punishment is I might be inclined to always do the same thing, right? I might always be inclined to say, well, this type of cases, I'm more inclined to do prison. I'm still going to consider everything. All I'm asking is you have to look at the menu, right? I might be inclined to always do one thing, but I'm not going to say I will not maybe order something else. I might not do something else. Does that make sense to everybody? Okay. So that's what, if I talk about it, this court talks about it, whether the defense talks about it, that's what we mean by consider the full range of punishment. Of course, that doesn't mean you are going to give it. Doesn't mean that you might be inclined one way or another to do something. It's just you have to at least menu and consider. Is there anybody here knowing that this is the range of punishment cannot consider the full range of punishment? Is there anybody here who says I cannot consider probation? I won't even open the menu and look at it. Error number 17. 44, 61, 62, 29, 69, this is 72 already. 72, 33, 34. Again, this does not mean that you say, I'm willing to give somebody probation. It just says, I will consider it. Doesn't mean that you ever will necessarily, but you will not even consider it. Did anybody miss anybody's card?
Yeah, right here.
You're number 7. So this is another scaled question that I have for you. What is the purpose of punishment or sentencing somebody? So you have to pick one of the two, whichever one you more identify with. What is the purpose of it? Punishment. The defendant needs to be punished for the consequences of his actions, or 2, rehabilitation. I need to help the defendant, reoffend. So again, number one is punishment, number two is rehabilitation. What is the purpose of sentence? Who falls into category number one, punishment? Let's see, more cards up than I expect down, so I'm gonna just go, who falls in category number two, rehabilitation? I see 23. You gotta choose one. If you could stand for me, I'm sorry, what's your number? 30.
That was my question. Both.
Whichever you more identify with.
Because you don't identify more either, because I think if you're gonna get punished, you definitely answer for it if you're guilty, but if you just answer for it with no rehabilitation, you send them back out there and go to the same thing. And if you're just getting rehabilitation, you just went through a class or whatever it is, and you still not answering for a crime. And if I think you can make the decision to definitely answer for it.
Right, and I'm not saying that they can't be a mixture. I understand, everybody's kind of probably on the spectrum of, well, I want some rehabilitation with some punishment. Or I might have more punishment than rehabilitation. It's just whichever you fall more, whichever you more identify with more. Okay, I'm not asking that you can't consider both. This is just how you initially react to it. I'm sorry, you're number 53? Yeah. Right? If you're
I can't hear her.
she can't hear you, you can stand for me. 52.
If you punish them for what they did, obviously they need to be punished, but to prevent them from reoccurring, what would be the process of taking, so, something like that.
This is not to say you can, I'm not trying to say you gotta pin you one down, you're not gonna consider rehabilitation. I'm not gonna consider punishment if I more focus on rehabilitation. It's just, what do you think is, which one do you identify with more? Which one is more important for you? Okay, who falls into category number two, rehabilitation? You're number 23, 46, 47, 50, 55, 60, 67, 71, 73, and 74. Okay. Getting low on time, so I'm just going to kind of get to these final questions. Anybody know anybody who's ever been accused of this crime or a similar crime, sex crime involving a child? Anybody know anybody who's been accused of a crime or a similar crime, so a sex case involving a child? Juror number 17, 3, 23, 29, 31, 36. So if you turn your card around, please. 40, 41, 42, 43, 55, 59, 67, 69, and 72. Out of those who raised their cards, does anybody feel that that person wasn't given a fair shake? That they weren't treated fairly through the system? Juror numbers 55 and 67, juror number 72.
Yeah, that question you meant like being accused or?
The person being accused. Juror number 31. Yes, sir.
So in the outcome of the trial from the court martial, the individual that was over 18, my stepdaughter that was under 15, it was overseas. And it was never registered in the US system for sexual offenders.
Okay.
And I felt that the difference between the military system and coming back to the States was a complete disconnect. So that person today has no record whatsoever in the system.
Thank you. Juror 43. Okay, so take 43 off of that. This is probably the more things that people are likely to respond to. So there's this long-standing study, the adverse child experience study, it's 8th study out of Kaiser Permanente. I'm so sorry, putting those things words on the record. That looked at the long-standing study. So really, the outcomes of it is that 1 in 4 girls and 1 in 6 boys are some victims of some type of sexual abuse growing up. So it's pretty common. And so part of this is I need to figure out if anybody here has such an experience that they cannot sit in judgment. So anybody here, anybody or are themselves a victim of child sex abuse? You can raise your cards. 3, 10. If you or anybody you know you're close with been a victim of child sex abuse. 3, 10, 11, 12, 14, 17, 18, 23, 24, 25, 26, 28, 29, 30, 31, 32, 34, 35, 40, 41, 42, 43, 55, 56, 58, 59, 61, 64, 69, 72, 73, and 75. Yes. ma'am. Yeah, that's this. Yes. 37. Out of those who have raised their cards, is there anybody here who says, based on that experience or based on my relationship with that person, I cannot be a fair and partial juror on this case? And what I mean by that is that I cannot set aside that experience or that relationship, that knowledge, and not insert it in reaching a verdict in this case. So what we ask of you, is that the judge is going to ask you, is that you listen to the evidence in this case and you base your verdict just on the evidence in this case, right? Not that you're inserting some belief or experience in reaching that verdict, right? This experience as a, knowing or a child sex abuse victim. So with that kind of explained, is there anybody here who says, I cannot set aside that and this would affect my judgment in this case in reaching a verdict? See, 3, 10, 17, 24, 26, 28, 29, 32, 35, 50, let's say 42, 58, 67, 69, 72, and 75. I'm just gonna skip the last couple questions because I'm running out of time, I'm sure. Does anybody have any questions for me about what we talked about today? Okay, thank you guys so much for your time. I look forward to seeing the next couple of days with all of you. Thank you, Judge.
Thank you. Everyone, we're going to take a short break. So I'm going to have everyone come back in at 4:05. So everybody's rushing. Make sure, excuse me. Didn't let you go yet. You got to know the instructions. So what that means is that everyone has to leave the courtroom and make sure that you're lined up side. So look to your left, like on paper chase, look to your right. Remember the person who's next to you. Make sure they're next to you when you line up in the hallway. All right, everyone, please rise for the jurors. Leave your numbers behind. Those are very expensive.
Yeah, put the AC on, please.
The AC is on. We didn't have it for a couple of days.
There would be cell phone numbers. Okay. 20, yeah, I'll give. We don't know.
Kaiser Permanente, and I was like, oh god, she's gonna write that down. I didn't mean to use the word policy.
I have cones, just not how.
I wasn't purposely doing that one. I was legitimately.
Well, and I already knew that story, so I got it. Well, I already emailed her. Oh, okay. You're allergic to that. I didn't even need it, I just. I only either get peanut M&Ms or this with because I feel better having that for now. Like it's better for years.
I mean. I don't know, brother.
Dying over here. Yeah, it's hot.
All right, everyone, please be seated. Defense, are you ready to proceed?
Hey, please, this honorable court, State's Counsel, Mr. Stevenson, my client, and ladies and gentlemen of this jury. First of all, thank you so much for coming here, taking time out of your day. It's not easy to take time off of work, take time away from your normal everyday duties to do a service. And I just want to tell you on behalf of my client in the state of Texas and this judge that we are very grateful. Mr. Morganfield here is basically telling you I'm innocent. Everybody, please repeat that. I'm innocent. All right, because he's been accused of a crime, nothing more, nothing less. There's a presumption of innocence that anyone who sits there accused of a crime has. All of our forefathers, people who have served in this country since the inception of this country, have provided, died for, and given their all, served their country so that those of you who are accused have valuable constitutional rights that you possess, especially if you're accused of a crime. And one of those most valuable rights is a jury trial. So that's what we're doing here. My client is saying he is innocent. It's the state of Texas's burden to prove each and every element of a case. So I want you to think about that. If it were your mother, your father, your brother, your sister, your grandmother, your grandfather, your cousin, niece, your very good friend who was sitting here, would you not all want that presumption of innocence? Is there anyone here who can't do that? So this is serious business. This is serious business, and I want you to think of it this way. If you can't fulfill that duty, then all those people who have died before to preserve that right, the constitutional right to a jury trial, will have died in vain. And I literally mean that. I've won multiple cases where jurors have found my clients innocent in this courtroom and all the other courtrooms here in Bexar County. I've been practicing law for 33 years. And I do it because I love it. And I do it because I know there are a lot of people who are found charged with a crime. This is their only way. Do you know what it takes to indict somebody? A scintilla of evidence.
Judge, that's a misstatement of the law. It's preponderance.
No,
Gotta be-
to indict.
Gotta be sustained.
So basically, you have someone who's accused somebody of a crime, and they can be charged. And the only way that you can get out of that situation, in many ways, many times, is with a jury trial. So I know some of you who've come into this courtroom today, the state is asking you, and literally, I'm not asking you because I know you can't do it. But our system is based on a situation where we're asking you to put away your biases and prejudices at this door. You gotta just forget about them all. Well, I don't want you to do that. And many of you already haven't. But I presume that some of you still haven't put away those biases and prejudice. The judge isn't going to ask you to put away those biases and prejudice. She wants you to be fair and truthful in this process. So I want you to be honest. Think about this. When you saw this young black kid here, sitting here, accused of this crime, how many of you already thought in your mind that, you know what, he's got to be guilty of something? How many of y'all really felt that way? Be honest. When you saw him sitting there, you figured, boy, this kid has to be guilty of something. Be honest, tell me, how many of you here felt that way? Anybody? This side of the room. Anybody? This side of the room. Nobody? Thank you very much for your honesty. Now let me ask this another way. When you heard that he was charged with a sexual assault of a child under 17, there were some of you who said that I can't sit on this jury. A lot of you said that. And that's exactly what I'm talking about. I'm talking about that you just could not be a fair and impartial juror on this kind of case. Because you have in your own mind a bias or prejudice. And there's nothing wrong with it. Nothing wrong with it whatsoever. You're entitled to that. You're entitled to that. And it's nothing to be ashamed of. It's how you feel and how you're going to, and you're telling us the truth about how you feel. So thank you very much about that. So I'm going to go one step further. The judge talked about this a little bit. So let's make a hypothetical that you found somebody guilty of sexual assault of a child. And some of you said that, a few of you said that you could not consider probation in the light of giving it. Or in another way is putting that you could not consider probation towards a low end of a sentence. And mind you, this is after you found somebody guilty. So I'm going to ask you again, after I put it that way, that you have found somebody guilty. Because nobody wants to go against the judge. Certainly, nobody really wants to go against the state. But I'm begging you, I'm imploring you, because this is one of the areas of law that needs to be considered if punishment is done. And those are the things I worry about. If you found someone guilty, could you consider probation with a light towards giving it or giving a low end sentence? Who here cannot do that? in the first 12 here. Next.
I have a question.
Yes, sir.
That's not what was asked.
I understand, but that's the way I'm asking it. Okay, so
But then you asked two different things. The first time you brought it up about sexual assault of a child, and now you're just asking in general.
I know I'm saying in sexual assault of a child, because you're going to be sitting on that type of case. So if you found someone guilty of sexual assault of a child, who cannot consider giving probation or a low-end sentence. Number 3, be honest, ladies and gentlemen. Number 7, number 8, number 9, number 11, number 10. Yes, sir.
I would consider any prior offenses before I would
Sure.
decide.
Understood.
If it's a first offense, then I would consider probation. If it's not, then maybe not.
Understood.
You said number 9, but I thought.
Oh, were you 6 or 9?
No,
I thought you raised yours. Sorry, my bad. Anybody else over here on this side? Number 17, 20. Okay. The law requires that if you find somebody guilty on this type of charge, you're to be able to consider the full range of punishment. And part of that is probation. So some people just really believe if I found someone guilty of a sexual assault of a child, there's no way in hell I'm going to give them probation. And certainly I'm not going to give them the low end of a guideline or low end of a sentence. In other words, I'll give more towards the higher. So if you can't consider giving probation or can't consider a low end sentence, then you're really not considering the full range of punishment. Yes, sir.
Can you explain, so probation would be something that is in lieu of a sentence?
Probation would be, you wouldn't go to prison. The judge could sentence someone up to 180 days, I believe, as a condition of probation. But I'm talking about can't consider probation or a low end sentence after you found somebody. So please raise your hands again. I'll have to go start again. Number 14. Let me just start again. 3, 8, 10, 11, 6, 7, 14, 17, 20, 24, 25, ma'am, 30, 33, 29, 34, 35, 44, 47, 50, 58, 61, 62, 69, 72. Thank you very much. Now, let's talk a little bit about the burdens of proof. Proof beyond a reasonable doubt is what you have to prove. I'm gonna have to speed up because I don't have a lot of time left here. But let me tell you what I believe that is. There's no definition. But if you're going to find someone guilty of something, you have to prove it beyond a reasonable doubt. In other words, in your heart, you know your decision is right. There's no equivocal going back and forth. Is he guilty or not guilty? Does everybody understand that? That you are sure to your core. It's like those decisions when you decide.
Judge, at this point, I'm going to object for the defense attempting to define beyond a reasonable doubt.
All right, ladies and gentlemen of the jury, there is no definition of beyond a reasonable doubt. Does everyone understand?
Yes, ma'am.
It would be those kind of decisions, like, for example, if you decide to get married, is she the right girl or guy? If you get married and you decide, is this the right house? And God forbid with the mother-in-laws, am I moving out of town with my daughter or my son? Or is it, am I going to have a baby now? Is it time? That's what your frame of mind should be when you're thinking about proof beyond a reasonable doubt. Because clear and convincing evidence is another standard in the civil courts. That's the standard that they have where a jury might decide whether you're going to take a child away from a parent after an abuse allegation or something like that. Unfit mother or guardian or grandparents. That's clear and convincing evidence. And then you have preponderance of evidence in a car wreck case where Lady Liberty's just proved more than 50%. You win. So proof beyond a reasonable doubt is the burden of proof that the state of Texas must prove. It's not clear and convincing, like the evidence you take away a child from. It's you made the right decision. They made their case, proved each and every element by beyond a reasonable doubt. And do not fail ever to hold them to that burden. Do not ever give them the benefit of doubt on that. You hold it to them because that's what the law requires. We talked about grand juries. It's easy to get here. That's how we got here. And in a grand jury, the defendant can't even be in there. Or his lawyer can't even be in there. It's the state of Texas presenting their case. How fair is that? So that's why he's saying I'm innocent today, because there's no other way. Now, this is going to be difficult. I think it's important because it's always come up one way or the other. Race matters. And if I didn't bring it up, I would be doing a disservice to my oath of practicing law, to this young man. If any of you believe that you can't sit on this case because you have any bit of bias or prejudice, please tell me now. The judge is not going to hold it against you. The state's not going to hold it against you. I ask that if you have that feeling, have the courage to say it. That's your ticket home. Anybody. It's difficult to admit, but I've had people say it before. Think in your soul, is there anybody here that because the color of his skin is not going to give this man a fair trial? Thank you very much. Before I close, I just want to mention one thing. The credibility of witnesses is something that you need to consider. I tried a capital murder case, death penalty case a few years ago. The state's witness, their main witness actually, was a state sheriff deputy who testified that the confession that he got from my client was something that he wrote out. Well, cross-examined him, had him testify, and the sheriff's deputy said, yeah, he gave confession. He took his time, but he was able to do it. Took a little bit of time. Got the state's doctor to testify, yeah. Yep, he did it. That confession's valid. But guess what? The guy couldn't read or write. He was looking at the death penalty. All right. So my expert found out he's mentally retarded, or you can't say that word no more. But his mental abilities were not where they should be. Back then, that's the term they use. And that psychologist that worked for the state violated a lot of ethical parameters. The jury found my client not guilty, even though he stabbed this person multiple times. It was a not guilty because that jury said, we're not going to give you the benefit of doubt. We're not going to give you state a victory at the expense of those people who fought and died to preserve our right to a jury trial. And we expect that the state will be honest. And most importantly, those of you who are picked on this jury, listen to nothing about anything other than the credibility of the witnesses from the beginning to the end. Thank you very much.
you, Mr. Hancock. My name is Ben Stevenson, and I have had the privilege of practicing in Bear County for over 18 years. I have known my client for over 4 years. And I'd like to continue a few things Mr. Cantrell was talking about and speak on a few others. I'm a little bit older than my counterpart over here, which means that I am used to extemporaneous speaking and not quite as comfortable with PowerPoint. So if any of you are going to judge me for not using PowerPoint, please don't. I will try to keep it interesting. I will try to keep it moving. And I want to thank you all for being here because all of you guys have lives, families, jobs, other things, other places that you would rather be. There's probably not a one who would rather do this than whatever their next best option is. So thank you. Without you coming, responding positively to the summons that you received, many people who have been accused would not have any recourse. They would not have anybody to judge the facts and to stand up for them if they believe that. Wanted to talk a little bit about the words bias and prejudice. We don't like those words, and when we don't like those words, we tend not to apply them to ourselves. Bias, I'd rather use some different words like maybe my opinions or the sum total of my life experiences. When I first got married, one of the things that my wife said is that she would never own a German Shepherd because when she was young, her sister got mauled by a dog and she's pretty sure it was a German Shepherd. Last year, we ended a wonderful almost 12 years of owning a German Shepherd. She was the sweetest thing. It took a long time for my wife to get over her fear of German Shepherds because she was educated as a child. Now she had a bias, she had a prejudice. She wouldn't have called it a prejudice or bias. It was just her opinion. It was what she grew up with. It was something that was a knee-jerk fear reaction. She sees a German Shepherd. She thinks, my sister got attacked. I need to ask everybody a question, and I would just really appreciate total honesty here. It's just as important that you be excluded from this jury if you are not the right fit than it is that you be included in this jury if you are the right fit. It's just as important. I need absolute honesty here. Has anybody on this jury ever been attacked or maliciously harmed by a Black person? Has anybody ever been victimized by a Black person? Out of 75 people, not one person has ever been victimized by a Black person of color. Again, thank you for your honesty. We grow up being taught to be fair to everyone. You don't call certain people certain names. We all have to work together. America's the melting pot. The problem with that is that while we say these things and we try to live them out, there is also a very clear idea of who is us and who is them. Each of us got brought up in our own subcultures. There's our friends. If you were brought up in a church, there's the people you go to church with, civic organizations. There was people within your groups, and those were us. And everybody outside of those groups was them. Now, it's easier to draw inferences about who us is because you can think, what am I like? And then you can say, well, the people in my group are probably like me. Who are them? Who are they? What are they like? Well, I'm not quite as sure because they're not as much like me. I heard a statistic a long time ago that tested Oriental persons of Oriental descent, and they had them differentiating people of different races. And this Oriental test group found it very difficult to differentiate between people of Caucasian descent because I heard one person say all white people look alike. I'm white. I don't think we look alike. But the thing is, that's another example Nobody's being malicious here, but it's this idea of there's us and then there's them. And I'm not saying anybody's bad, and I'm not asking anybody to feel shame. God made you who you are. Man, woman, black, white, any other color. Don't be ashamed of who you are, but realize that who you are and the experiences you've had have built an idea over the years of who is us and who is them and what can you expect. If you're walking and it's getting kind of late and you're not in an area of town that you're familiar with, and you realize that somebody is following you about 20 feet behind, you turn around, it's a white woman. Or you turn around, it's a black man. You're going to feel different impulses based on who it is. And those are going to be factored in, and those are going to be the result of everything you've ever learned since you were old enough to remember until now. What I'm going to ask you to do in this case, you are going to hear witnesses that are not black. You may hear witnesses that are black. What I'm going to ask you to do is, before you make decisions, if you hear an accusation that a black man did something to a white woman, before you decide your verdict, knowing all of the evidence and the testimony you've heard, I'm going to ask you, switch it up. Ask yourself, if I've heard all this evidence, but it was a white man, and it was a black woman, and I had heard all this evidence, seen all this evidence, heard all this testimony, would I still be coming to the same conclusion? If that changes your answer, then that is an example of implicit race bias. Nobody's trying to, but it's there. And the first step toward overcoming that and making sure that we have a fair trial is realizing that all of us have experiences, all of us have used thought patterns of us and them, but the person's color should not determine the outcome. The evidence, the testimony, they should. Statistically, Bexar County is 9% black. That means of every 100 people in Bexar County, 9 of them are black. That means that blacks in Bexar County are a minority. And that's all I'm going to say about that right now. There are a few laws that the state has shared with you today. I'm going to share a few more just because they're important. The two main bodies of law that we draw from for criminal trials are the Texas Penal Code, which says a lot about what's legal and what's illegal and how the process is supposed to work, and also includes the Code of Criminal Procedure, which says even more about how the process is supposed to work. But I want you to have a little bit of Texas law in your mind as you walk into this. One of my favorite passages of Texas law, it's at the very beginning of the Penal Code. I don't know how many of you can read this. I will read it to you. Section 1.02, it talks about this is the Texas Penal Code. Here are several reasons why we have the Texas Penal Code. One of them is to safeguard conduct that is without guilt from condemnation as criminal. One of the reasons that we have the law is so people can know, hey, if I'm not breaking any of these laws, then I'm okay. And I shouldn't have to worry about getting arrested. Because I should be able to realize, hey, I've got a safe harbor here. That safe harbor is I'm not breaking the law, so I shouldn't have to live in constant fear that I'm going to be harassed or arrested. The next couple are not going to be quite as big just because there's a lot of words in here. I'll read these to you also. This trial is going to be about a couple of different laws. Both of these are found in the Texas Penal Code. Texas Penal Code section 22.011 describes sexual assault, and sexual assault of a child. It defines a child as anyone who's under 17. And it also provides for an affirmative defense. What is an affirmative defense? An affirmative defense means that if this is proven, case over. Because a defense that is provided for by law, if the person meets the defense, then it is no longer a crime. It says 22.011 section 8, it's an affirmative defense to prosecution as long as it's based on age of the alleged victim and not based on consent. That the actor was not more than 3 years older than the victim, and that at the time of the offense has never been a registered sex offender. And that the alleged victim was a child at least 14 years of age, which means between 15 and 17, and there is no bigamy or incest involved. A lot of people call this the Romeo and Juliet provision, which means that if two teenagers, very similar ages, the youngest one is at least 14, they're not more than 3 years apart, there's a defense here. Very similar. Indecency with a child. Indecency with a child means sexual touching. It is an affirmative defense. We said an affirmative defense ends the case by making it not a crime. It's an affirmative defense to prosecution under the section that the actor was not more than 3 years older than the victim and was of the opposite sex. Did not use duress, force, or threat against the victim at the time of the offense, and at the time of the offense has never been a registered sex offender. So if a person doesn't use force or threats, is not a registered sex offender, and is not more than 3 years older, case based on touching, affirmative defense, case over, not a crime. Back in the first chapter of the Texas Penal Code, that was where we found the construction of the code, the safeguard conduct from prosecution that is not objectionable. We also find this section. Texas Penal Code 1.06, computation of age. This should be short enough that everybody should be able to see the words. A person attains a specified age on the day of the anniversary of his birthday. That means if I'm 19 years old and I'll be 20 next month, how old am I today? 19. I didn't hear anybody say 20. The law says you're right, 19, because you have hit your 19th birthday, but you haven't hit your 20th birthday. Now, to see if you've been paying attention, I have a 1-question math quiz. Pull this down so you don't see the answer yet. What is 19 minus 16? 3. Is there anybody in here who says 19 minus 16 does not equal 3? Let me see your hand. I think most knowledgeable people would agree with you that 19 minus 16 does equal 3. There are, number 44, you had a comment or question?
I had a question. You're going over a lot of laws that protect the defendant. Where are the laws that state that the victim should be protected just as much? Because if I'm not mistaken, I served and knew people who died, not to protect the rights of the defendant, but to protect the rights of every American.
I agree. And you're absolutely right.
So where are those
I'm
laws?
picking and choosing some of these. I represent 1/2 of this trial.
Okay.
The state over here represents another half. I'm not going to say anything that is untrue, and I'm going to do the best I can not to get anybody else to say that anything that is untrue either. But at the end of the day, I'm here because the state is fighting against my client, and my client has a legal right under the Constitution to have somebody fighting for him. And without somebody fighting, pulling on either sides of the tug of war, the machine doesn't work. So me being here fighting for my client validates the result. Without me doing my best, the machine wouldn't work. And it would almost guarantee an appeal if I didn't fight my best for my client. So that's why I do it. I also do it because many people, surprising number of people are falsely accused. And there are certain types of crimes that people get falsely accused of more than others. And there's some crimes that are very difficult to defend just because naming the crime makes you want to believe the person is guilty because it sounds so horrible. And that's why we were asking those of you to please be honest. Who of you could not sit in judgment on a case like this without leaning so far to one side or the other that they could not consider everything, including all of the range of punishment, including probation? And for every one of you who was honest when we asked you that question, we're grateful. But that was a very good question. We are only part of the legal system. At the end of the day, there is a judge, and that judge is not me. And the judges of the facts in this case will not be me either. The judges of the facts in this case of what is true and what is not true will be the 12 people selected to be on this jury. And it is your job to be impartial. It is my job to make sure that at the end of the day, my client has been fought for. Just like you would want your son or your daughter, if they were accused of a horrible crime, you would want them to be fought for. Thank you for the question. Good question. There are going to be different theories of the case. It's possible that at the end of the case, some people on the jury might think not a crime because we fall within the 3-year exception. We fall within the Romeo and Juliet. Another portion of the jury might think not a crime for some other totally different reason. If a jury does not agree on the reasons that a person is not guilty is still not guilty. Just like the state was saying, there may be small details that you may not all agree on, but if you agree that the defendant is guilty, if you agree that they've met their burden of proof on each and every element of the offense charged, then you will still find guilty. All we're asking for is the flip side of that. That if some of you believe that the state has not met their burden of proof or that there's actual innocence for another reason, and some of you disagree with what that reason is, not guilty is still not guilty. We are not allowed anymore to tell you what reasonable doubt is. It is a term of common usage. And we ask you to bring your knowledge of the English language and your common sense into the courtroom and take it with you into the jury room. What I do want to say is that the word reasonable, as in reasonable doubt, it comes from the word reason. Reasoning means thinking. Reasoning is doing mental work. Can I have a show of hands? How many of you here have ever seen the old black and white movie 12 Angry Men? It's a classic. The only thing that the star of that movie asked is what I asked. A man's life hangs in the balance. Doesn't he deserve a little bit of our time so that we can think things through? And when you're thinking things through, I don't want you to check your brain at the door. I don't want you to just find out how the majority is voting and go along because you don't want to make waves. If you are willing to go along with the majority and not make waves, then legally you should not be on this jury. Every single member of this jury should be ready to stand up for what they believe in, whatever that ends up being. And you should listen to the whole trial. You should listen to both sides, including closing arguments, before you decide what do you believe. But once you know what you believe, we are utterly depending on you to stand on what you believe. And if that means that there are 11 people who are angry at you, you are being a hero for being that one person who stands for what you believe. I have to ask another question here. Imagine that you're in the jury room and the other 11 jurors all want to vote to convict. But for some reason, which you haven't even heard yet, just playing suppose, for some reason, you believe that the state has not met its burden of proof. You do not believe that the state has proven beyond a reasonable doubt that my client is innocent. I want each and every one of you to commit that if you are that one, you will not let the 11 turn you if that's what you believe. I'm not going to ask for a show of hands on this one because it's more important that you think about it than that we make a show. But we are counting on you. That if you are that one, that we can count on you to stick with what you believe and not be turned because the other idea is more popular. When you are processing all the information that you're going to be hearing in the next few days, think, look for details. They say the devil's in the details, but a lot of times the answers are in the detail. That little pesky thing that keeps coming back to your mind that bothers you and you're not quite sure what to make of it, keep thinking about it. The state talked about various ways that you can know if somebody is lying or telling the truth. In poker, you call them tells. Somebody has got to tell, like if somebody's got a winning hand, suddenly their nose it. So there are things, and who knows what you're going to see as far as tells this week. Pay attention to them. When the human body lies, there is something about lying that goes against the grain. And we don't like it. Our bodies don't like it when we lie. So a lot of times there will be tells. There will be, I can't look at you while I'm lying to you. There may be other things. There may be nervous twitching. Who knows? But just please work your minds on this one. Pay attention to the details. Remember that a man's life is hanging in the balance. My colleague talked about the right to the presumption of innocence. The state has to prove beyond a reasonable doubt each and every element of each and every count before you can vote guilty or not guilty on that count. And unless they have met their burden of proof for each and every element, the presumption of innocence alone is enough to come back with a not guilty verdict and acquit. My client has the right to remain silent. Over the next week, you'll find out whether he chooses to testify or not. He may have a terrible stutter. He may have a really squeaky high voice. We don't know. You'll find out if he chooses to testify, but he has a legal right not to. And the law says that if he chooses not to testify, he has that right. And the state has to convict him without his help. He can say nothing at all, and if the state still hasn't met their burden of proof, by law, you have to acquit, unless the state has met their burden of proof, whether or not my client says anything at all. If my client chooses not to testify, you can't consider the fact that he chose not to. You can't think about, well, if he had talked, here's what we think he would have said. The state can't talk about that either. The law in this case states that if a person is found guilty of indecency with a child by contact, or if a person is found guilty of sexual assault of a child, both counts, second-degree felony by law. Second-degree felony means confinement of anywhere as little as 2 years to as high as 20 years. And if it's no higher than 10 years, then he could get probation. The same body of 12 judges, you, the jury, who are going to be on the jury, are not going to just get to decide that, but if worst comes to worst and you do vote to convict him, right there, you can see I'm biased. The same 12 are going to be called upon and depended on to listen to all the facts that you will hear, to make sure that regardless of where you land, you have at least considered everything from the low range, little as 2 years, including possible probation, up to the high end. Let me ask you a question. We talked about whether a person testified or not. If a person is accused of sex crime and he doesn't testify, which ones of you, to be honest here, would really be uncomfortable if a person who was accused of a sex crime did not get up there and say, I didn't do it? Who would have a problem with that? 33 have 2, 11, 10, 8, 22, 18, 15, 20, 24, 32, 37, 29, 44, 40, 47, 49, 50, 48, 61, 62, 65, 67, 69, 72. Which of you would have a big problem with this and would have a really hard time finding a person not guilty of a sex crime if they did not take the stand and testify?
Oh, add mine too.
Add number 3. And the number 35. Just to be very clear, 31, thank you. I have a good question. Go ahead. I'm gonna ask a slightly different way, but could I ask you to hold your question for a moment? I'm gonna ask it a different way, and that might make it clearer. If my client chooses to exercise his constitutional right to remain silent, in all honesty, from your heart, who would hold it against him if he chose to not testify? Who would hold it against him? I have 2, 33, 20, 35. I'm sorry, I'm just gonna start again. If you're in the main section, please keep holding your things up. I have 2 and 3, 8, 10, 11, 9, 7. In the far side of the room, I have 20, 24, 22, 34, 35, 33, 37, 40, 44, 47, 48, 49, 50, 61, 62, 65, 67, and 69.
For 18, did you raise your hand or you did not?
Did that answer your question? It did not. Did you still want to ask a question? Go ahead. What's your number? 31. Go ahead, sir.
Just my education, because I'm not familiar with the process as much. My first impression when I got here, you mentioned that 9% of the population is African American. And I realize that we're all Americans first and foremost, and I'm former military and I serve with the Air Force now. I know that we have a huge military population that's very diverse. I'm curious, everyone wants to be tried by a jury of their peers. I'm wondering the Bexar County process by which, I could be wrong here, but I don't know that there's 9 African Americans among 100 people. So I don't know, military or exempt, is that accurate?
It depends what 100 people.
But are military exempt? Is that an exception when they get?
I'm not prepared to answer that question. Okay. What I will say is that if this was a cross section of what you could expect from Bexar County, then we would expect approximately 7 people in the jury pool instead of 3 to be persons of color. 3 possibly 4. Okay. Wanted to also mention, you had mentioned something else. I talked a little bit about race. So one last thing I did want to mention very briefly on race, just so they're kind of fleeting. The Constitution gives us the right to a jury of our peers. If we are accused of a crime, we have the right to be judged by a jury of our peers. But just like we talked about the groups of who is us and who is them. If a defendant is black, who are his peers? What would a jury of his peers look like to a defendant who is a young black man? Would it be a different set of peers than somebody who is a 60-year-old white female? And please consider that also as you are trying to make sure that you are thinking very fairly and open-mindedly about things. I did want to ask a few specific questions regarding specific jurors. One of the things, I don't mean to single you out, but juror number 29, we did not get a questionnaire for you. And I'm sorry to single you out like this, but I need to ask you a couple of questions if everybody else answered. Juror 29.
Send it to the mail. I don't know.
Okay, for some reason, we didn't get it. So I needed to ask you just a couple really easy questions. Have you ever been involved in any kind of a criminal case as a witness, as the accused, or as a juror?
No.
Do you have any relatives who are law enforcement? No further questions on that. I have a question for juror number 7.
Yes,
You had mentioned earlier that you were hard of hearing.
yes. Sir.
Has it been hard for you to hear some of the words today?
No, I've been able to understand today,
Most of the words or all of the words?
most of the words.
Most of the words, okay, so not all of the words.
No.
Understand. Juror number 32, I believe that you said that you have a doctor's appointment coming up in 2 days, is that right?
Thursday afternoon at 2:30.
Thursday afternoon at 2:30. If we were still in trial, that would create a hardship for you, is that correct?
That is correct. It's a respiratory. I'm on meds.
I'm not medical, but I understand that breathing is important. Would you agree? Don't stop doing it.
No, that's the whole idea.
Okay, I wanted to ask, some of you said that you've been involved in a criminal case in the past, and I just wanted to ask a couple basic questions. Juror number 5, you mentioned that you had been involved in some way in a criminal case in the past. In what capacity were you involved?
Yeah, when I was in my, in the 90s, my ex-wife accused me of assault. And the case was dismissed because I reported her admitting that, yeah, I know you didn't do it, but I told you, left me. I was gonna make your life a living hell. But she did make my life a living hell.
So in your case, you'd say the legal system worked the way it was supposed to then?
Well, I have a lawyer, and I recorded her admitting to it.
Okay.
The problem is that I didn't get my money back.
Got it. So, yeah, I agree with you there. Juror 14, you said that you had been a juror in the past, is that correct?
Yes, sir.
What was the charge? You know what the person was accused of?
Shoplifting.
Okay. And did you guys vote to convict or to acquit?
Acquit.
Okay. Juror number 25. You said that in some way in the past, you had been involved in a criminal case. In what way were you involved?
Just as an accused in a couple cases when I was younger.
Okay. Can I ask, and I'm sorry to be nosy, but may I ask what you were
They
accused
were
of?
both possession charges,
Possession charges?
marijuana.
And did those go to a trial?
Did not.
They did not. Did they go to probation?
One did.
Very good. Nothing for juror 25. Thank you for your honesty. Juror number 48. Thank you for standing. You had mentioned that you were involved in some capacity in a criminal case in the past. Is that correct?
That's correct.
In what capacity were you involved?
I was a witness to a robbery.
You were a witness to a robbery. So did you end up testifying at trial?
I was sent letters that they couldn't work it out, that they did get a plea.
So ultimately, while you saw something and you came forward, you didn't have to testify in trial.
Right, no, I didn't.
Got it.
I was
Okay.
just a witness overall.
So this is the closest you've ever been to a criminal trial.
Yes, sir.
I understand. Thank you so much. Juror number 55, you had mentioned, where's juror 55? You had mentioned that you'd been a juror before, but you didn't say whether it was criminal or civil. Do you recall? Was it a criminal case?
It's been years, I can't recall.
Excuse me, I'm gonna need you to speak up so that the court reporter can
Was
hear.
it about, did it have to do with a crime? Do you remember? Okay. Do you remember whether on the jury, did you guys vote guilty or did you guys vote not guilty? Do you remember how it ended?
Yeah, it was,
You are not guilty? Okay, thank you. Finally, juror 63, or juror 63. You had indicated that you had been a juror on a criminal case at some point in the past, is that right? What was the charge? Sexual assault. And did your jury vote to convict or did your jury vote to acquit? Convict. Thank you so much. We have about 5 minutes left. A few of you on your jury questionnaires indicated that you have family members who are law enforcement, and we appreciate good law enforcement. Law enforcement is supposed to protect and to serve, and when they're doing their job, they're wonderful. I have my best friend is a law enforcement officer, so I'm grateful for the good ones. Jury number 4, I had a question. You said you had a relative who's a law enforcement officer. What is their relationship to you?
My tia, my aunt.
Your aunt, okay. And you wanted to ask you kind of a strange question. Do you think it's more likely in a trial, if somebody gets up there, swears they're going to tell the truth, the whole truth, nothing but the truth, is it more likely that they're telling the truth if they're a peace officer?
5 minutes.
Thank you. Juror number 10, same question. Let me rephrase it a little bit. Is it more likely, are police officers more likely than the general public to tell the truth on the witness stand?
Depends on the person.
Okay. And you say you had a relative. What is that relation to you?
Uncle.
Your uncle. Okay. Juror number 14. What is the relationship of a law enforcement person to you?
Brother-in-law.
Brother-in-law. Do you like your brother-in-law?
Absolutely.
If an officer is on the stand, is it more likely, less likely, equally likely that a law enforcement officer is going to tell the truth rather than the general population? What are your feelings?
More likely.
Why?
Been around a lot of law.
Okay.
Mostly good.
Mostly good. I'm glad that they're mostly good. Where's juror number 27? You have a relative who's law enforcement? Yeah. What's the relationship? My cousins. Your cousins, multiple cousins? Cool. Based on your dealings with your cousins, would you think that a law enforcement officer is more likely, less likely, or equally likely to tell the truth on the stand?
I would say more likely.
Why?
The reason why is because I hang around my cousins and their friends who from the police force to just kind of see, how they carry themselves and their personalities. I believe that they're good people.
Okay.
So
you said they're good people, so good people make good cops, and they're good cops. You're saying, right? Okay. Have you ever heard of cops that weren't good cops?
yes, but
Okay. Where's juror number 40? Juror number 40, you have a relative who's law enforcement. Who is that relative? You used to be law enforcement. Okay. So what force were you on?
I was military police.
Military police. For how many years? 6 years. Thank you for your service. What branch? Same question for you. Is it more likely, less likely, or equally likely the person who's an officer is gonna tell the truth?
I think it's the same for any general population.
Okay.
They're human.
Do you think it still means something when people take the oath to tell the truth? The whole? Thank you. Juror number 44. Where's juror number 44? Same question. Is a person who's a law enforcement officer more likely or less likely to tell the truth on the stand?
More likely.
More likely because
They are.
they have honor. Okay. Thank you. Juror number 49. Probably the last one I will have time for. What is your relationship to a law enforcement officer in your family? Father-in-law, your father-in-law. Do you think it's more likely, less likely, or equally likely that a person who's law enforcement is gonna tell the truth on the stand as opposed to somebody who's not law enforcement? And more likely because of.
They're held to a higher standard. They have sworn oath.
I think that's all the time that we have. Thank you so much for your attention, and thank you in advance for all the time and all the mental effort you're gonna put into this to make sure that no detail is missed. Thank you.
All right, ladies and gentlemen, what I'm going to do is I'm going to have you step outside. Please leave your cards behind, and all of the people who are in the box, make sure you take your items with your personal items with you. But everyone, please leave the cards behind. And if you stay outside in the hallway, we'll call you back in. Y'all can just wait outside, please.
Excuse me, if you all will wait until jurors come out. That's whatever you need to do.
Yeah, I've been.
that person could not consider probation. He was found guilty and
Did he say he would not give probation, or did he say he would not consider probation? Because what was the question asked?
I asked him to change that question and specifically said he could not consider giving probation for the low end of the sentence.
Well, it's not him giving it. It's supposed to be whether or not they would consider it. So did number 7 say that he would not consider probation?
Yes, Your Honor.
Yes, Your Honor.
Okay, state.
Should, based on how the questions were asked, I don't believe that at any point that there was established or cause based on low end of the probation, low end of the sentence or probation. Because he framed it, and I have this in quotes in my notes, or would you give more towards higher?
Then the very last question, though, because I asked him that, I thought there would be some problems with that, so I asked him to change that question.
All right, who else? Who else are you speaking of with regards to that issue of range of punishment?
Number 11, 8, 14, 6, 20, 35, 25, 34, 30, 33, 47, 61, 62. And that's it on that question.
29 was also on
All
that.
right, 29.
Could not
Sorry.
consider probation.
All right, and what other issues that you have that the state is saying they won't agree to?
Well, we have an issue with the person that admitted that he was hard of hearing and got most of the testimony, but not all of it.
We pinned him down. He said he did not hear everything. He could not hear everything.
That's
It's
what
pretty
number is
important
that?
that somebody hear
Which
everything.
number is that?
And number 7.
All right, that's going to be denied for that. You already have him for range of punishment. So what other issues do you have?
Number 32, I believe, was one of the people who had said Thursday that he's got a doctor's appointment, the breathing issue.
Yes.
All right, who else do you have?
And then 69, I think that was the teacher. And then 61 was the student.
All right, 69 is the teacher who has to be at her class.
Yes.
I'm not going to grant for that. And then you
I
said
think they have statutory exemption and that was never asked.
they're
69
here.
is a vacation.
They should have used it at the other, they should have used it before they came to court. And I don't believe they necessarily have a statutory exemption, but no, and they didn't ask to be excused. And who else?
That is everybody else. Oh, what about the law enforcement people? There was, besides number 44, there was 2 other people.
I did not take notes. I simply asked the questions on that. If they would find somebody who was not law enforcement to be less credible because they were not law enforcement. I only got up into the 40s.
I think that they were.
If you took notes, then we have notes. If you did not.
Somewhere.
And number 14 for your range of punishment, that's already been agreed to on, I guess, other
Yes, it
issues.
has. It has, Your Honor.
No.
Number 44 is gone. So we would ask number 14, 27.
You've already agreed to 14 with this 8.
27.
And what is the issue with 27?
Number 27 said that he would believe law enforcement over the general public when they testify. And that's not, if we have a witness that just believes someone's a law enforcement officer just because they're a law enforcement officer, and they don't believe, and that person's credibility is more than someone who might contradict that law enforcement person, then we're at a disadvantage at that point. So,
That is a prejudice.
that's correct, Judge.
Judge, just quickly, the question that was asked was whether law enforcement would be more likely to tell the truth. And then not framed in a way of as it relates to other witnesses or comparison to other witnesses. And I believe that they're allowed to take into account a police officer's training experience in order to determine their credibility and whether they're telling the truth or not. That wasn't framed within that context.
I believe that we asked them that if you believe a law enforcement person only because they're law enforcement, would you believe that person more than someone who is not law enforcement, who's testifying? If they have a bias to that, then my client's prejudiced because he wouldn't get a fair trial, because he would right off the get-go believe that the person who's on the stand, if that person is contradicted by law enforcement, you would believe that law enforcement person. So for those reasons, we have asked that.
It's just not a level playing field.
All right, that's going to be denied because that wasn't the question that was asked of the prospective juror.
Are you looking at the question, Judge? Up there?
No, I listened to I listened to everybody's voir dire.
And so then we would object to 14.
14 you all have
I'm
already
sorry,
agreed to.
44 and 49 for those same.
44 you've already agreed to.
Yes. Okay. Then 49 also.
Okay, that will be denied. All right, so with regards to numbers, my understanding is y'all agreed to number 3, is that correct?
We did agree to number 3.
All right, so please write these down. So number 3 is agreed to. Number 5 is agreed to. Number 10 is agreed to. Number 14 is agreed to. Number 17 is agreed to. Number 24 is agreed to. Number 26 is agreed to. Number 28 is agreed to. 32 is agreed to. Number 42 is agreed to. Number 50 is agreed to. Number 58 is agreed to. Number 67 is agreed to. Number 69 is agreed to. 72 is agreed to. And number 44 is agreed to. Are those the agreements?
Judge, could you give me the first few before number 1 through 14?
Sure. All right, 3, 5, 10, 14, 17. Number 21 was excused by agreement. 24, 26, 28, 32, 42, 44, 50, 58, 67, 69, and 72. That's what's agreed to. Is that correct?
Reports with our records from the state, Your Honor.
Defense, is that what is agreed to? No. You guys want to step back? All right. So with regards to juror number 7, juror number 7 says they have VA appointments for next week. Does anybody anticipate this trial going into next week?
I don't anticipate even with, if we were to get to punishment judge.
Juror number 7 is also the person who admitted being hard of hearing and can't hear everything.
Okay, we're gonna make sure he hears because we have the microphones. So he says that he has appointments on the 15th, the 17th, 26th, and 29th. Is there a possibility that this trial is going beyond this week? The state is saying no.
Your Honor, I think there is an appreciable chance. I can't see the future, but if we're not even starting the cases in chief until Wednesday,
Oh, it's all day Wednesday.
understand?
Yes.
And assuming all day Wednesday, all day Thursday, and all day Friday, I think there's a possibility because once we get to the end of our case in chief, we've got hammering out jury charge, we've got closing arguments, we've got deliberation. And then if they come back after a day of deliberation with a guilty verdict, we're into next week.
All right, that's why I have alternates. Okay, so is there an agreement to number 7? Anyone?
Judge, I just don't anticipate we're gonna get that far. We're not gonna get into that.
All right. And then we have the person, number 69, that person is going to Grapevine. Is that agreed or no?
I've already agreed to 69.
Okay. And then number 5 is already agreed to. Number 68 says they have a conference on Thursday.
Thursday, 2 days from now.
They didn't qualify. They said Thursday.
Oh, that's the conference call, Judge.
Yes, the conference call with the military.
It was just hard based on his. I might get the call, I might not get the call. I'm still waiting to hear back.
So are you going to agree to 68 or no?
No, Judge.
We didn't have an issue with them, so.
Okay. All right, and then we have August. Someone has surgery August 26th. Is anyone just anticipating this going to August 26th?
God help us now.
Okay. And then the person who has the daughter who has the wisdom tooth, that's being removed on August 16th.
16th is Monday, right? Tuesday.
Tuesday.
Go ahead, state.
And then on the 12th, juror number 12, that's the heart transplant.
They're getting a heart transplant on the 12th?
No, they're taking the relative.
That's this Friday.
Mhm.
I think there's a very high chance that they'll still be here, and I do not want a resentful juror if possible. We would ask to strike for compassionate reasons on that if the state has agreed.
Any-
Judge, my notes weren't clear. You said that she's on Friday.
On the 12th, August 12th.
Okay, we can agree to 12.
So 12 is agreed to. And then number 32. That's been agreed to.
What number is that again, Your Honor?
That was 32. They have a doctor's appointment on the 11th, but you all already agreed
that
to
was already-
32. Just 1 second.
The only one that judge that I think we missed is 65. My daughter has a neurology of driving.
All right, juror number 65, yeah, It says Monday and Friday, there's a doctor's appointment with the daughter, neurology.
We can agree to 65.
Depends, are you in agreement to 65?
65. Yes, yes, we agree.
All right, 65 is agreed to. No. Maybe. All right, could I see jurors 6, 11, and 8, please? If y'all can slide this way a little bit more. Hello. All right, your jurors 6, 8, and 11, is that correct? 8. All right. All right, 6. 6, 8, 11. You guys are all out of order. That's okay. All right. So here's the question. In this case, the range of punishment, if you were to find someone guilty, the range of punishment is anywhere from probation or either anywhere from 2 to 20 years in prison. Do you understand the range of punishment? Is that a yes?
Yes.
All right. So if someone were to be found guilty, the answer is whether or not you will be able to consider that full range of punishment, not necessarily give it. Does everyone understand? So you have to be able to consider whether or not, if you were found someone guilty, whether or not you think they're deserving of probation, whether or not you think they deserve 2 years or all the way up to 20 years. Does everyone understand that? Is there anyone who feels like they could not consider probation or 2 to 20 years, the full range of punishment? Is there anyone here who could not consider the full range of punishment? I'm sorry? And what's your number? And what's your number? All right, could you consider the full range of punishment? I'm sorry? All right, and what's your number? And could you consider the full range of punishment? All right, is there any other questions from either side on the issue of full range of punishment?
Nothing from the state judge.
Yes, Your Honor.
Yes.
Yeah, your number is? Earlier, the question was, after you found somebody guilty of aggravated sexual assault of a child.
That's not the
I'm
charge
sorry,
here.
Sexual assault of a child. Would you be able to consider the light toward giving probation or lower in sentence?
Not give, consider.
Consider.
Yes, I think I was just gonna do this one.
All right, so you would be able to consider giving probation or lower in sentence after you found someone guilty. All right, ma'am, same question. All right, ma'am. Good night.
Can I repeat the question?
Sure. You sat and listened to the trial. You have found someone guilty of the offense of sexual assault of a child. Now you go to the punishment phase. In the punishment phase, one of the things is available for defendant for your consideration is whether or not you would consider giving that person, after you found him guilty, consider giving him probation or consider the possibility of giving him a lower end sentence. Are you able to do that? You're able to do that. So you're waffling back and forth.
Oh, no.
So Is it you don't understand the question or you're just not sure or?
I'm not sure.
Let me ask you a question.
Mhm.
Your number is again?
Eight.
Your juror number.
Mhm.
There was a question asked before, and we're trying to identify people who, for one reason or another, just really didn't feel like they could sit in judgment and be a good juror on a case of this kind. Would you say that you're somebody who would have just a really hard time being a good juror on a case like this?
No, the question that we are here for is whether or not she can
Apologize.
consider the full range of punishment.
Stricken.
So what's your juror number?
8.
8. All right, so juror number 11 and 6, you can go back outside. Thank you.
Mhm.
All right. So,
Okay.
all right, do you understand their question?
Hey, Judge, I know this is a little out of turn, but we can have an agreement outside the presence of 9 members. It relates to this.
All right, thank you so much. You're excused. You can go back outside. Thank you. Okay, that's an agreement to number 8. With regards to jurors 11 and 6, defense, do you withdraw your objection?
No, Your Honor.
Okay. All right, can you bring in jurors 20? I'm sorry, juror number 11 and 8, your objection is overruled. Can you bring in jurors 20, 25, and 30?
It just refers the record, Judge, you have objections to.
He's asking to continue with his objection for cause with regards to 11 and number 6, and that will be denied.
So
Yes.
for
You said 8.
I'm sorry, thank you.
I mean, I said.
It was an agreed strike.
All right, 8 is agreed to, all right. Thank you.
I was trying to be.
No, I appreciate it. Hello, all right. Oh, just come up to the front, everyone. All right, who is juror number 20? All right, can you step here? Who is juror 25? Okay, and you're juror number 30. All right. All right, I just have a question for you all with regards to range of punishment. And remember, we're speaking in hypotheticals because you don't know anything about this case, right? So the range of punishment in a case of similar nature, a person could receive probation, or either they could get sentenced anywhere from 2 to 20 years. Does everybody understand the range of punishment? Now, when people ask you about that, if someone were found guilty, they're not asking you what you would give. The question is, could you consider the full range of punishment? That means you consider probation, doesn't mean you have to give it. That means you consider 2 years. It doesn't mean you have to give it. That means you consider 20 years. Doesn't mean you have to give it. It's because if you're on the jury, you'll have evidence before you and you can make an informed decision on whether or not someone's deserving of probation or whether or not, the full range of punishment up to 20 years. So knowing that, is there anyone who can't consider the full range of punishment? We'll start with you, juror 20.
Okay, so my philosophy is if I was to deem somebody guilty of this crime, that in my eyes, I thought they were guilty, then I don't think I would be comfortable with giving them just probation.
Well, it's not whether you are comfortable. Remember, I'm not talking about giving them. Okay, all right. And juror number 25?
I would consider a couple range.
All right, thank you. Juror number 30?
If I'm not giving it, I would consider the whole range. If I were to give it, then I wouldn't give probation. Understand?
Yes, I understand what you're saying. All right, any questions? State?
Nothing from the state.
Defense, you have questions. You want to start with juror number 20?
No, Judge, we'd ask that you instruct the cause.
Well, no. Do you have any questions for juror number 20?
Here's what. No,
All right. Do you have questions for juror number 25?
no, Your Honor.
Do you have questions for juror number 30?
Yes, I did not understand her. answer.
She says that if I'm the person to give punishment, I would not give punishment as probation. I would consider more of the punishment, but if I'm to look at the whole probation too, if I'm not the one giving it,
and it's the judge, I can consider the whole range. But if it was up to me, I'm the judge, I wouldn't
not
give
consider
probation. I
All right,
would
juror
not.
number 25, you can step outside.
Okay.
Thank you.
That's the truth.
Yeah, no questions for 25. All right. Any other questions for 30 from either side?
I don't.
All right, thank you. Jurors 20 and 30, you can step outside.
Thank you.
All right, with regards to juror number 20.
We got set.
Wait 1 second. All right, juror number 20,
We would ask that juror number 20 be stricken for cause.
that'll be granted. Juror number 25. Juror number 25,
We withdraw our objection, Your Honor.
juror number 30,
We move to strike for cause, Your Honor.
that'll be granted. All right, could you bring in 33, 34, and 35? I promise you, no one would bother it. All right, are you 33? All right, if you could stand right there. What's your number?
33.
All right, if you could stand right there, and 34, if you can get in the center for me. All right, do y'all understand the range of punishment in an offense of this nature? All right, so the range of punishment is anywhere from probation or either 2 to 20 years. Does everyone understand? All right. Now, when people talk to you and ask you about range of punishment, you haven't heard any facts of any case, correct? All right. So what they're asking you is whether you would consider the full range of punishment. They're not asking you if you will actually give a specific range. Does everyone understand? So nobody's asking you if you would give somebody probation. Nobody's asking you to give them 2 years, 5 years, 20 years. Nobody's asking that. What they're asking you is if you would consider it. And so if you were on a jury and if someone would be found guilty and you're sitting in punishment, you would probably receive something so that you can make a decision on the range of punishment based upon what you hear, if you hear any evidence based upon that, or based upon maybe what you heard in trial. Does everyone understand? All right, so juror number 33. Are you able to consider the full range of punishment in this case?
Yeah.
Okay, juror number 34, are you able to consider the full range of punishment? Juror number 35, are you able to consider the full range of punishment?
Yes.
All right, any questions, State?
There you are.
All right, thank you, you're excused. Sorry. All right, could you bring in 47, 61, 62, and 29? Yes.
No.
And jurors 33? Defense,
We ask that person be struck for cause.
Yes, sir.
that'll be granted. 34,
We ask that person be struck for cause.
that will be granted. 35,
We ask that person be struck for cause.
that'll be granted. You guys need to slide over that way.
So what's the first time you running 47?
It's 29, 47, 61, and 62.
Okay.
All right. All right, jurors number 29, if you could stand there. Who's 29? Okay, right there. Who is 61? Excuse me, defense. Can you all slide
sorry.
over? All right, and who is 62? And who is 47? All right, so I have 29, 47, 61, and 62, correct?
61.
You're 61? All right, you need to switch places, okay? 29, 47, 61, 62. All right, so this is my question for you all. You all understand the range of punishment in a case of this nature? It's anywhere from probation or 2 to 20 years in prison. Does everybody understand? Is there anyone who does not understand the range of punishment? All right. So the question that is asked is whether or not you can consider the full range of punishment. It's not whether you'll give somebody probation, it's not whether you'll give somebody 2 years or 20 years. Is there anyone who disagrees with me when I say that in order to actually give a sentence, you would have to hear something so you can make an informed decision? Is there anyone who disagrees with that? All right, so that being said, is there anyone here who could not consider the full range of punishment in this case? Juror number 29, are you able to consider the full range of punishment?
Yes.
All right, juror number 47, are you able to consider the full range of punishment?
Yes.
Juror number 61, are you able to consider the full range of punishment? Juror number 62, are you able to consider the full range of punishment? All right, thank you. All right, juror number 62, you can step outside. All right, any questions, defense?
Yes, Your Honor. It's fine. Juror 29. Yes. Originally, we asked you a question that after you found a defendant guilty with a hypothetical, that guilty of sexual assault of a child, would you be able to consider granting probation for that person after you found him guilty, and also consider given the low end of punishment? I believe you said you were not able to do that after you found somebody guilty. Is that correct?
When I said it is correct. Considering also the scope of what the charges are, like if it's, for example, if somebody is out there with 3 different, somebody mentioned.
Understood. So the question again is, are you able to consider full range of punishment, which would include consider giving probation or consider giving a lower end of the range of punishment? If you can't do that, then you need to tell the judge you can't do that.
Yes.
You can. Same question to you, sir.
All right, and your juror number? All right, you can step outside.
I would say no.
I'm sorry, he's going to that next week. That's okay.
Well, to the question of if you found them guilty, it's no.
That you could not consider giving probation or the low end of the guideline. No. And that's you also, ma'am, right? That's what it's.
All right, any questions?
No, Judge.
All right, thank you. If you'll wait outside. All right, defense?
We'd ask, I guess 62 was the first one.
47 was the first one.
47. We'd ask that that person be struck for cause.
All right, that'll be 9. They said that they can consider the full range of punishment. The first one.
Sure.
That was
29. That was 29.
Oh, I am so sorry.
47 was the Spider-Man shirt who said he couldn't.
All right, state. Are you withdrawing your objection to 29?
I'm
Yeah.
not, I'm gonna say no, we still object to 29 because there's this hesitancy there and what he originally said,
All right.
he was more accurate with what he originally said as far as what he believes and feels.
That will be denied. All right. Now 47,
We'd ask that person be struck for cause.
state.
Judge, it keeps going back and forth, and I think when you talk to them and you clearly explain the law, they might unequivocally say no. But I mean, yes, they can, because there's a full range of punishment. And so based on that response, we don't believe that they're to be struck.
All right, I'll grant that. Yes, 61.
Your Honor, we would move that 61 be struck for cause, said they could not follow the law.
That will be granted. Well, not follow the law. They said they would not
With
consider
regard
the
to
full range of
considering
punishment.
all the all range.
All right, 62.
Your Honor, defense moves that 62 be stricken. They said that they clearly not follow, or consider the whole range.
We have no objection.
All right, that would be granted. All right, so we're off the record for a moment. Okay, these are the ones. And then we'll go on the record just to make sure you have them. 3 is agreed. 5 is agreed. 8 is agreed. 10 is agreed. Yes. 10 is agreed. 12 is agreed. 14 is agreed. 17 is agreed. 20 defense cause. 21 excused. 24 agreed. 26 agreed. 27 agreed. 29 defense cause. 32 agreed. I'm sorry, not 29. 30 is defense cause.
We had 28 and 30.
Excuse me. 30 for cause, not 29. 29 is still on the panel. 32 agreed. 33, 34, and 35 is defense cause. 42 is agreed. 44 is agreed. 47 is defense cause. 50, 58 is agreed. 61, 62 is defense cause. 65, 67, 69, and 72 are agreed. All right, so we're going to go on a record to make sure we have it correct. All right, these are the following juror panels that were agreed on. Number 3, 5, 8, 10, 12, 14, 17, 24, 26, 28, 32, 42, 44, 50, 58, 65, 67, 69, and 72. Is that correct, State?
Yes, Your Honor.
Is that correct, defense?
It is a list of the ones that were agreed, I believe. We were going through the list first, and when you went through the list first, listing everything.
My question is, do you need me to call the agreeds out anymore? Or do you all agree that those are the ones that you agreed on?
We agree that those are agreed. We agree that more were granted because one side of the other.
I haven't gotten to those yet. I'm just concentrating on the agreed. So do y'all agree on the agreed ones that I've just called out?
Yeah.
All right. Then the person who was excused was 21. For defense cause, 20, 33, 34, 35, 47. Is that what both sides have?
I have also 30, Judge.
I'm sorry. And 30.
Yes.
All right.
61 and 62.
And 61 and 62. So does everyone agree to that?
Yes, Judge.
All right. Just give me one moment. So I have the strike zone is 53.
That's what I have, Judge.
There's a few more people that we would like to follow,
No, that's all we're calling up.
or we objected to some other ones.
What are you objecting to?
Well, juror number 22.
For what purpose?
would hold it against him if he did not testify. And there's a few more we need to add to that.
No, did they say they would hold it against Mr. Morganfield if he didn't testify?
Yes.
Or did they say they would want to hear what someone would have to say?
We specifically asked if they would hold it against.
Brenna, can you see if that's in the record?
Just give me.
So there's three.
Pretty much.
I have, if the question was, if a person is accused of a sex crime and he doesn't testify, then which ones of you, be honest here, would really, really be uncomfortable if a person who was accused of a sex crime did not get up there and say, I didn't do it? Who would have a problem with that? And then you want me to say the numbers?
No.
Okay.
Did I ask it again after that?
Okay, then you asked, which of you would have a big problem with it and would have a really hard time finding a person not guilty of a sex crime if they did not take the stand and testify?
Yeah. All right, so let me give you the strike zone.
We need to put on the records the people that.
Sure. All right. Brenna, if you can call out the numbers after that second question.
Oh, I went away. Okay. Yeah, I have 33. Then you said I have 2. I have 11, 10, 8, 22. Wait, the second question or the first one?
The second one.
Okay, sorry. Okay, he didn't get the numbers and then he asked a slightly different way, but could I ask you to hold your cards? I'm going to ask it a different way and that might make it clearer. If my client constitutional right to remain silent, in all honesty from you, who would hold it against him if he chose to not testify? Who would hold it against him? I have 2, 33, 20, 35. I'm sorry, starting again. If you go to 2, 3, 8, 10, 11, 9, 7. In the far side of the room, I have 20, 24, 22, 34, 35, 33, 37, 40, 44, 47, 48, 49, 50, 61, 62, 65, 67, 69.
Thank you, Brenna. So 3 is already gone. 8 is already gone. 10 is already gone. 20 is already gone. 24 is already gone. 35 is gone. 34 is gone. 33 is gone. 44 is already gone. 47 is gone. 61 is already gone. 62 is already gone. 65 is already gone. 69 is already gone. And 67 is already gone. So that leaves 2, 7, 9, 11, 20, 33.
20 was already gone, Judge.
On our list, 20 is already stricken. You see, state agree.
Yeah, yes, that's true. And that leaves 33, 37, 40, 48, 49, and 50.
33 is already gone, Your Honor.
All right, thank you.
And 50 is already gone.
So then that just leaves 2, 7, 9. 11, 37, 40, 48, and 49. State, any objections to number 2?
And I just make a global response to this.
Yes.
Um,
So with regards to number 2,
for all of the minutes you're gonna call, Judge, we believe that the way that it was framed, especially with the 2 questions, and the fact he said, I'm going to frame it in another way, with the 2 other questions clearly not being cause questions. I don't believe that this establishes a challenge for cause, and so on hold, all the numbers that you've called out, that would be a response to those for 9 numbers.
defense?
Your Honor. 50 amendment is a pretty heavy right, and each of these said unequivocally that they would hold it against my client if he does not testify. That repairs our defense, and that is going to taint the outcome, and it would make an unconstitutional playing field. We move to strike for cause.
All right, juror number 2, that would be granted for cause. 7 for cause is granted. 9 for cause is granted. 11 for cause is granted. 37 for cause will be granted. 40 for cause will be granted. 48 for cause is granted, and 49 for cause is granted. All right, that puts the strike zone at 64.
I like we have more challenges, Judge.
And you have one extra strike between jurors 65 through 71.
65 was agreed, right, Judge?
Yes, 65 is agreed to. So the numbers that have been agreed to are 3, 5. Defense, are you taking this down?
Yeah, this is everybody, right? We're talking about.
We're talking about the ones that have been agreed to. So the ones that both parties have agreed to is 3, 5, 8, 10, 12, 14, 17, 24, 26, 28, 32, 42, 44, 50, 58, 65, 67, 69, and 72. Is that correct, defense?
Appears to be, Your Honor, marking these as we go.
State. The one for cause by defense, 2, 7, 9, 11, 20, 30, 33, 34, 35, 37, 40, 47, 48, 49, 61, and 62. Is that correct, defense?
Yes, ma'am.
State, is that correct?
Yes, Judge.
All right, and the person who's been excused was juror number 21. Is that correct? State,
Yes, Your Honor.
defense? So the strike zone,
Your Honor,
yes,
I show one more juror as stricken, but I did not hear that juror on this list. Can I confirm whether juror 27 is stricken?
no,
Juror 27 is not stricken.
no,
Okay, thank you.
you're welcome. All right, so your strike zone is to 64. And you get one extra strike, and that strike must be used between jurors 65 and 71.
And to confirm the number of peremptory strikes per side, Your Honor.
All right, everybody should, yeah, it's 10.
We'll go to the jury room, Judge.
Not doing an alternate. Not doing an alternate.
Yeah.
All right, these will be, Brenda, we're on the record. These are the jurors, number 6, 36, 39, 41, 46, 51, 53, 54, 55, 57, 59, 60, 68, and 70. Any objections?
Your Honor, would the court be graciously willing to read that again? We were checking off as fast as we could.
6. 36. 39. 41. 46. 51. 53. 54. 55. 57. 59. 60. 68. 7. Any objections?
I hear, please, Lupe. Yeah, for the stress.
You have 15? We have 15 jurors, Your Honor, which would be 12 and 3 alternates. Is that the court's intention?
No, there's not 15. That's 14. There are a total of 14.
Okay.
Any objections from the state?
No,
Any objections to the defense?
No objection from defense.
All right, let's bring the jurors in.
You can sit anywhere.
Oh,
Anywhere, as long as you both start going all the way to the end. Just go all the way to the end, all to the end. To the end, to the end, to the end. Yes, yes, just all the way to the end, so everybody has easier for everybody to go. Okay, so we can sit anywhere? Yes.
Anywhere.
Is that everything to get a seat? Oh, really? All the way to the end. That is gonna be for the jury. Yes. Is that everything's gonna be in the front seat? Just, yes. And everybody else is just that. Just come on in. Come on in, come on in. The door has to close.
All right, everyone, be seated. All right, ladies and gentlemen, thank you for your service. Usually we don't keep people here this late at night, but you should thank everyone because you've beat rush hour traffic. So there will be no rush hour traffic when you leave. So I always say, look on the bright side. So does everyone have one of those square white sheets of paper?
Nope.
All right, so make sure you didn't take two. Pass along one if you don't have one. What you can do is you can turn that in and you will receive money for your services here today. And you can do one or two things. You'll get that paycheck in the mail probably about a month or maybe 2 months. And you will say, oh my gosh, this is great. I can have lunch. Where did this come from? And then you'll remember the great time you had in the 187th. Or you can actually donate what you receive, and they have plenty of organizations you can donate it to, and it will go to that organization. Before I call the list of the people who are going to be on the jury, just remember the courtroom is always open to the public. I always try to demystify the process for people so that you can learn what happens in trials. So as I call your name, I'm going to need you to take a seat in the jury box. Griselda Bernal. Madonna Fallon. And I promise I'll learn how to say this last name at some point. Jennifer Patakis. Regina Rodriguez. Caitlin Chang. Esmeralda Valdez. Kimberly Garza. William Gates. Maria Prado. Adam Flores. Joanne Elizondo. Eugene Vega. Joe Flores. And Daniel Neal. And for the rest of you, when you leave for validated parking, just let them know when you're going out that you were in the 187th. All right. All right. You all are excused. If you want, I can have you call back for tomorrow as they rush out. Thank you all. All right, so I'm going to give you all instructions because I know you're ready to leave us for now. These are your instructions. Just 1 second. All right, we're going to start tomorrow at 9 a.m. So we cannot start unless all of you are here. Now, sometimes the parking garage fills up. So in order to make sure you have a great parking space, if you come a little bit earlier, you'll probably have a parking space for you. Because if you can imagine, a lot of courtrooms have jury trials going on. So the same number of people that you all probably seen on the Zoom link, that's happening every day. So usually every courtroom, at least on the felony side, usually has about 70 jurors that they're calling. So that's a lot of people when you think about it. So I would suggest getting here earlier than 9. When you come tomorrow, you're not going to come to this courtroom. Deputy Laura is going to show you where you need to report to. So don't report inside the courtroom. Does everyone understand? Now, the temperature in here, there's a thermostat right there. I have absolutely no control. If I were to put that thermostat on 0 or 20 degrees, nothing would happen. So usually in this courtroom is extremely hot. Sometimes, which hasn't happened in, I don't know, since 2019, sometimes it may be cold. I always tell people to prepare for any eventuality. So it's better to have a jacket or something. You can take it off if it gets too hot. You're more than welcome to bring something to drink or water. Just make sure you have a cap on it. So if it won't spill over if there are accidents. I don't expect any publicity or anything with this case, but you are not allowed to listen to anything about this trial. You're not allowed to go out and do your investigation on this case. What you need to make, the decision you need to make in this case will be based on evidence that you hear inside the courtroom. Does everybody understand? So if you happen to be on Facebook and you see something about this, you need to turn it off. So no social media about this, nothing about it on the news. If you see something on the news, just turn it on a different station. If your neighbor or something hears something about this and she wants to talk to you about it, or he wants to talk to you about it, just tell them you can't talk about it. You're going to be given badges, and those badges are going to signify you that you're jurors in the 187th District Court. Whenever you're walking around in the courtroom or around, we're going to want you to wear those, because sometimes you have attorneys or family members or other people talking about different cases, not necessarily this one, but maybe they may be talking about other things. And when they see that you have a juror badge on, then people won't talk around you, because they'll know that's, persons on other jurors, and we don't want to interfere with anything in the trial. Does everyone understand? Yes. All right. So we're going to come in tomorrow you all going to be here at 9 a.m. Deputy Laura is going to show you where to go. All right. Is there any questions? All right. Oh, we're going to let you get that. The other thing, if at any time you're hearing testimony or you can't hear something, just let us know. Somebody in the courtroom will see it, either via attorneys for the state or the defense. If you ever need a break, just let me know. Deputy Laura says this is always the good symbol for break. So if you're in the jury box and you need a break, just do that, and somebody will see you and they'll let me know that you need a break, and you'll get a break. Okay. All right. Is there anything else before? Yes.
Is this gonna last more than just tomorrow?
Possibly.
Okay.
Yes. All right. Yes. All right. Yes.
Is there a validation person to validate parking for today?
Oh, when you go out the parking, and Deputy Laura will let you know, just let them know on the intercom system that you're in the 187.
Okay.
Yes.
Hey, just to be clear, where are we meeting?
Deputy Laura is going to show you where you meet.
Oh, okay. Sorry.
Yes. Yes. And since you're going to be here, I anticipate all day tomorrow. Around lunchtime. If you want to bring your lunch, you can bring your lunch, or either there are plenty of places around the courthouse, and then there's a cafeteria downstairs where you can have lunch when we take lunch break. And I do give everyone a lunch break. All right. All right. Is there anything else? All right, then I will see you all tomorrow at 9 o'clock. And remember, we can't start unless you're all here at 9. All right, everyone, please rise.
You gonna get your stuff?